All right, we'll go ahead and take the recess sign off the screen and we'll go back on the record. And do we have a court reporter present at this time? All right, thank you, Madam Court Reporter. We do have a court reporter present. We will go back on the record. And we're back on the record in the case of Griffin versus Albanese, 2019 CA 1555. Let the record reflect that plaintiff's counsel, Mr. Kaczurgas, is present along with the plaintiff, Ms. Griffin. Our special magistrate, Ms. Hodak, is also present along with our remote jury bailiff, Mr. Muse. It is now a little after 2 o'clock and we were in lunch recess until 1:45. And I gave extended time, approximately 15 extra minutes for juror number 8, Ms. Joyner Rogers, to join.
Your Honor, it looks like she's in the remote jury room at this time. So I'm going to go in and just confirm, but it looks like she's currently there.
Okay, she must have literally just arrived then,
Yes,
right?
sir. Her picture went off screen, so it made me look, and it does look like she's present in the remote jury room, but let me double check.
Mr. Muse, if she is in there, then let me know. If she's not in there, I'll continue on. But if she's in there, please let her know. Let me know, but also let her know that she really needs to be mindful of coming back from the recesses on times it's holding us up.
Yes, sir.
And just say it in a polite way.
Your Honor, I confirm she is in there. Patrick will let her know.
Okay. We need to make sure she knows to come out of her recesses on time. Right. So going back on the record, the preliminary matters are that apparently Ms. Joyner Rogers did join us. Literally, as I was going on the record, she was arriving and probably answering that invitation to go into the remote jury room. So it's my understanding that all the jurors except for Ms. Joyner Rogers have already reviewed all the typical tech issues they have to review before they come in the courtroom. They were also going to do another demonstration of how to use the court technology to type out and submit juror questions for witnesses. And as soon as Ms. Joyner Rogers is through with that process, then if the bailiffs could let me know, and we'll bring all of our jurors into the courtroom. But as a preliminary matter, Mr. Kaczurgas, is there anything further I need to address preliminarily before the jurors come in?
I don't believe so, Your Honor.
All right, Ms. Hodak, anything from your perspective?
No, Your Honor.
Okay, Mr. Smith, is everything okay on your end?
Yes, sir. I think so.
Okay, so Mr. Kaczurgas, do you have I'm not going to hold you anything, but do you have a rough estimate as to how long Mr. Griffin's direct might last?
I don't think it would be any longer than an hour.
Okay, and you're going to use the remainder of your exhibits with him, or just some of them, or?
Some of them are going to be displayed through Mr. Griffin, but what I was thinking, just for presentation purposes, is probably go through them in the closing argument.
That's fine. That's up to you. I'm just trying to get an understanding in my mind as to how much time. So I'm thinking that when you're done with Mr. Griffin, will you be in a position to rest your case?
Yes.
So what will happen is when you rest your case, we'll take let's say a 10-minute recess with a jury, give them a comfort break, because I'm guesstimating that between my instructions and your closing argument, we could probably be looking at somewhere around another hour. Do you know how long your closing is going to be?
I don't think it'll be that lengthy. With pulling pieces of exhibits onto the screen will slow things down a little bit, but I would say probably not more than a half hour.
Okay, and I know my instructions will probably take a half hour or so to read. They're not too terribly long, but so I'm guessing around an hour, maybe a little over an hour, a little under an hour. That's a natural point at that point. So after Mr. Griffin will take a comfort break, we'll do the closing, my instructions, your argument, my final closing instructions, and then we'll send the jury in. And at that point, when I send the jury in, that's when our remote jury bailiffs will do the part 3 Zoom skills presentation. And once that's done, you'll leave. They'll pick a 4-person while we're in here confirming what's going to go back to them to review. When they hit the help button to notify us that they have a 4-person, so one of the bailiffs will go in there and confirm who the 4-person is, come out and let us know. And at that point, that'll be the signal to put everything into the drop box into the jury room that's supposed to go in there. And that process of what's going in the drop box will have to be confirmed between Mr. Kaczurgas, the court, the bailiffs, and Mr. Rogerson and Ms. Irizarry, our deputy trial clerks. Once that goes into a jury room, one of our remote jury bailiffs, as I said in my outline before, would have to go into the jury room to confirm, the remote jury room to confirm they've received the drop box or are able to open it. So that drop box will have the exhibits, my instructions, and then obviously saved electronically will be the electronic verdict form that they have to fill out remotely. So I think we're on this. Are we on the same page on everything that we talked about on Friday?
I believe so.
Okay.
Yes, sir. I believe so.
Okay.
Yes, sir. The one point of clarification, the verdict form will be done through Sophia, but with the
Right.
instructions will be given.
Right. The jury instructions will just be a PDF in the Dropbox.
Yes.
And those I've already provided to you all. And those are Mr. Ashley, who's the only person here in the physical courtroom with me, will be scrolling those as I read them to the jury.
Yes.
All right. So Mr. Muse has Mr. Esolila signaled that he's finished with juror number 8, Ms. Joyner Rogers.
Yes, Your Honor.
All right. So are all 8 of our jurors prepared to come back into the courtroom?
Yes, sir.
All right. Before you bring them back in, anything else to address before we bring the jurors in? All right, I see no indication of anything further. So at this time, Mr. Muse, you may bring the jurors into the courtroom.
Yes, sir.
All right, Mr. Muse, are all 8 of our jurors present and accounted for?
Not yet, Your Honor. We're waiting for one more.
All right.
All 8 are now present and accounted for, Your Honor.
All right, Mr. Muse, do you want to call us to order?
Yes, sir. The Remote Circuit Court Division CVE NN4 Duval County in the state of Florida is now in session. The Honorable Bruce Anderson is presiding remotely. Except for the remote jurors and the electronic devices they are using to participate in this court session, and the attorneys and their assistants, everyone please turn off all cell phones and electronic devices at this time. The attorneys and their assistants should have their cell phones and electronic devices silenced or on vibrate mode. Use of cell phone cameras or other electronic devices to take photographs or make video or audio recordings of these remote proceedings of any kind is absolutely prohibited. However, those of you in the remote gallery may use your electronic devices for purposes other than the photography or making any video or audio recordings of these proceedings while remote court is in session. Credentialed representatives of the media who have obtained prior approval from the court may use cell phones, cameras, laptops, iPads, and tablets, and any electronic devices, and they may be used for photographic and/or recording purposes. However, recording juror names and faces is strictly prohibited pursuant Second Amended AO 1992-02. There will be no talking while remote court is in session unless your microphone is muted. Except for the attorneys, everyone in the remote courtroom, including the remote jurors, should have their microphones muted unless called upon to speak or instructed to unmute their microphones. Justice to be served, the jury must be able to stay focused on the court proceedings. Therefore, talking or disruptive behavior by anyone in the remote audience will not be tolerated. To further reduce the risk of feedback, echoes, and distracting noises, everyone in the remote gallery observing this remote jury trial should have their microphones muted. A violation of any kind of these rules will result in you being removed from the remote courtroom.
All right, thank you, Mr. Muse. Welcome back, ladies and gentlemen, of the remote jury. I am so glad to see you back after lunch. I hope everyone had a good lunch recess, and hopefully you were able to find something good to eat during the recess. Everyone's ready to go this afternoon. I'm going to start out the same way I did every time we came back from previous recesses, which first of all of you that have other things at your desk or at your screen or within arm's reach, all that needs to be put aside, turned off, powered off, closed out of your screen. You should have nothing on your screen that other than this case. There should be nothing distracting you from this task at hand, which is first priority, which is this trial. If you have any paperwork on your desk that doesn't relate to this trial, that's not your notes, you need to remove those out of the way. There shouldn't be need to be doing any keyboarding at this point. And so I'm going to give you a moment to do all of that, power off your devices and everything else if you haven't already done so. The other thing I'm going to ask you to do right now is unmute your microphones. And the reason why is I'm going to ask you the same question I've asked you ever since I first met you, which is, can everyone hear me this afternoon?
Yes.
Yes, sir.
Can everyone see me?
Yes.
Yes, sir.
If there's anyone now that's having difficulty hearing or seeing me, please raise your hand. Let the record reflect that no one has indicated a difficulty as it concerns the court. And before we get underway, Mr. Kaczurgis, let's go ahead and test your system out as well. Mr. Kaczurgis, are you ready to proceed this afternoon?
I am, Your Honor.
All right. Can everyone hear Mr. Kaczurgis and see him?
Yes.
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 All right. If there's anyone that's having any difficulty, please let us know. And so the same rules apply as I've been giving you all along since we first met last week, which is if anyone has any technical difficulties, wave your hands, raise your hand, make an audible noise if you're able to. And if all else fails, call Mr. Muse or Mr. Smith. They are your lifeline for technology and many other things during the course of the trial. So with those things being said, we are going to pick up where we left off this afternoon. Mr. Kaczurgis finished his first witness before lunch. Mr. Kaczurgis, would you like to call another witness?
Yes, Your Honor. The plaintiff would call Charlie Griffin.
All right, Charlie Griffin will need to be invited into the remote courtroom from the remote attorney conference room. All right, good afternoon, Mr. Griffin.
Good afternoon, sir.
Mr. Griffin, based upon the prior stipulation by plaintiff's counsel that you are in fact Charlie Griffin, he has waived the requirement for the court to review your identification before swearing you in remotely. So could you please raise your right hand to be sworn in? Do you solemnly swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, thank you, Mr. Griffin. You can put your hand down. And Mr. Griffin, I'm going to do a sound check for the jurors at this time. Mr. Griffin, can you state your full name for the record and spell your first and last name for the court reporter and our trial clerk?
Yes, sir. It's Charlie Bernard Griffin. Charlie is C-H-A-R-L-I-E. Griffin, G-R-I-F-F-I-N.
All right, ladies and gentlemen of the jury, can you all hear and see Mr. Griffin?
Yes.
Yes.
If there's anyone that's having difficulty hearing and seeing Mr. Griffin, please raise your hand. All right, Mr. Griffin, I think you're coming across loud and clear, and you certainly look great there with your virtual courtroom background. So, Mr. Kaczurgis, you may proceed whenever you're ready.
Good afternoon, Mr. Griffin.
Good afternoon, sir.
If you could you explain to these members of the jury what your relation is to the plaintiff in this case, Cayla Griffin?
Cayla Griffin is my daughter.
And if you, likewise, if you could tell the jurors a little something about yourself. What'd you do in a prior life?
Prior life, I'm a retired Marine. Got out of the Marine Corps and went into the mortgage business, and now I'm retired fully.
Congratulations. What brings us together today is the case of Cayla Griffin, your daughter, versus Albanese Enterprises, Inc., doing business as Paradise. But before we turn to the events that bring us all together, I'd like for you to tell the jury what kind of daughter Cayla was to you growing up. What kind of kid was she?
I would probably say typical middle kid. She has two sisters, and Cayla's in the middle. Just happy-go-lucky kind of kid. Pleasant, friendly, outgoing somewhat.
Okay. I think there's been some testimony previously that she was a people person. Is that consistent with your observations bringing her up in this world?
She gets that honestly from her dad.
Okay. You're a people person too, I take it.
Yes, sir.
Yeah, COVID is tough on all of us then. And then if we can, I want to direct your attention into the fall of 2017 into the winter of 2018. And when Cayla decided to enter the field of exotic dancing, how did you feel about that life choice for your daughter?
I wasn't happy about it when I found out. But I mean, she's my daughter and she's an adult, so I'm gonna support her. But that's not something that I was happy about, but I supported her.
And in that, turning your attention to February 2018, where was Cayla living, or at least part of the time?
I'm sorry, repeat the question.
I'm sorry. Where was Cayla living in February 2018, or at least part of the time living in 2018?
With me, yes, sir.
Okay. Was that a consistent or here and there?
Here and there.
Fair enough. I want to direct your attention specifically to the late evening of February 2016, excuse me, late evening of February 16, 2018, early morning hours of February 17, 2018. Are you with me, Mr. Griffin?
Yes, sir.
Did you become aware of an incident involving your daughter?
Yes, sir.
How did you become aware, and what were you advised?
I was at home and I got a phone call. I think it was a young lady that called me and told me that I needed to get down to the club because there had been an altercation of some sort with my daughter and it was bad and I needed to get there.
Okay. So I take from that answer, you knew she was working at Paradise Gentlemen's Club.
Yes, sir.
Okay. And in response to that phone call, what did you do?
Jumped in my car and drove from Kingsland to Bay Meadows.
And I take from that answer, you were living in, is that Kingsland, Georgia at the time?
Yes, sir. Kingsland, Georgia.
Okay. Where do you live now?
Jacksonville, downtown Jacksonville.
Okay. But at that time, you had to drive from Kingsland to Bay Meadows Road here in Jacksonville.
Yes, sir.
How long did it take you to get there?
45 minutes or so, not doing the speed limit.
Okay. And when you arrived at the club, what did you see?
It was a police car at that time.
Mr. Griffin, I believe we're having a hard time hearing you.
How about now?
Much better.
Okay, I'll lean in.
There you go.
When I got there, I recall Cayla being in the police car. She wasn't handcuffed or anything. They just had her sitting in the police car. And when I got there, she was kind of passed out and kind of woozy, what have you.
Did you speak to anybody about why your daughter was in the back of a police car?
Yes, sir. I spoke with the at least one of the police officers, and they pretty much just told me that there had been an altercation there at the club, and they were still trying to sort through it. And I think, you know, and if I back up, when I probably initially got there and walked over to the police car and saw her, I probably tried to go to the police officer to find out what had happened and why she was looking like this and who did it.
Okay. I take her appearance was not as you were accustomed to seeing.
Not at all.
What did she look like?
Face swollen, eyes swollen, black, teeth knocked out. Just not what I'm used to and not anything that I would have expected.
Were you told why she was placed in the back of a police car?
I don't remember exactly. If I had to guess, they probably told me to kind of calm her down or whatever.
Okay. Did anyone tell you that she was being arrested?
No, sir.
Okay. Did anyone tell you affirmatively the contrary, that she was not under arrest?
Yes, sir. I mean, they told me that she wasn't under arrest or anything.
That's just where they were keeping her at the time?
Yes, sir. They were just holding her in the back of the car because she just needed to calm down. And you know, in hindsight, and probably even then, I'm thinking, how can she calm down? I mean, she's a bloody mess.
Fair enough. Had emergency medical technicians or paramedics arrived at the time, by the time or when you got there? Were they on scene already?
No, sir.
Okay, so you were there before the paramedics?
Yes, sir.
Okay. After having that initial conversation with law enforcement, what happened then?
The guys that were responsible, I saw them standing over there, and I mean, I think I probably did like anybody else would have done. You know, you see your kids sitting looking like that, and I tried to get to them, and the police stopped me.
Okay. How were you able to determine who the gentlemen were that did that to your daughter?
The police pointed out who they had talked to as the bouncers that the altercation had happened to.
Okay.
I mean, happened with, excuse me.
Okay. And understandably, you were upset about the situation.
Yes, sir.
Okay. After law enforcement restrained you from going after those gentlemen, what happened then thereafter?
Sometime shortly thereafter, not too much thereafter, that's when the ambulance came. And then I guess they started to treat her and, you know, put her in the ambulance to take her to the hospital.
Okay. Did they tell you, I mean, it may have been obvious, but were you told why she was being taken to the hospital?
I don't remember if they told me or not, but I mean, it was pretty obvious. I mean, she was pretty banged up.
Okay. Were you present when the paramedics or the emergency medical technicians were treating Cayla?
Yes, sir.
Was Cayla in a state that she could tell them what had happened, or was she out of it?
Again, by then, you know, they had placed her in the police car, and she was just kind of in or out of it, in and out of it. You know, she would be knocked out, just out cold sleep, and then she would wake up. What's going on? Why is this happening? What happened? Why am I bleeding? And, you know, just stuff like that. But she couldn't make solid sentences or anything like that at the time.
Okay. Now, when she was transferred to the custody of the emergency medical technicians and paramedics that began rendering treatment and preparing her for transport, were you present with those folks when they were with Cayla?
When they actually transported her to the hospital?
No, when they were on scene prior to transport.
Oh, yes, sir. I was there the whole time.
Okay. Did you ever hear Cayla tell anyone from the paramedics unit what her version of events was that night?
No, sir. Cayla didn't even know what happened to her.
She couldn't tell them.
Yeah, she couldn't tell them. I mean, the only thing she could do at the time was just, like I said, she would pass out and then she would wake back up and want to know what was going on and why. But Cayla couldn't make a sentence.
Once Cayla was loaded into the ambulance and transported to Memorial, what did you do?
Ask me that question again. I want to make sure I understand it.
Fair enough. Once Cayla or Miss Griffin was placed into the ambulance and loaded for transport, and the ambulance left with her to go to whatever medical facility, what did you do?
They left. I was still there. I went back towards the club to try and get in the club, and the police stopped me again.
Okay. Is it fair to say you were still hot about the situation?
Hot is probably putting it a little mild.
Fair enough. After that, what did you do?
Once I left, I went over to Memorial to the ER.
And you've been told that that's where Miss
Yes, sir.
Griffin.
They told me they were going to. They told me they were going to transport her to Memorial because there was a. I want to say they said it was some type of trauma center because of her head injury, so they wanted to take her to Memorial.
Okay. And you went over there as well.
Yes, sir.
And when you got there, what did you see?
I think when I was still at the club, it kind of soaked in somewhat. But once we got to the hospital and I could really see her, I think that's when it really just sunk into me, you know, what had happened to her. Because I mean, we're in light now, we're inside the ER. And so, you know, I can see the puffiness, I can see the blood still dripping and just her whole mouth. The top row of her teeth are just cracked.
Your Honor, permission to publish Plaintiff's Exhibit 2.
All right, you may so publish. And these are going to be photographs.
They are, Your Honor.
All right, you may use the share screen at this time. And before we go into the testimony, I'll check with the jury to make sure they can see the images. All right, for the record, it appears the photographs are on the screen that were marked as plaintiff's composite exhibit number 2. Ladies and gentlemen of the jury, I need you to unmute your microphones. Can all of you see the image on the screen at the present time with share screen?
Yes.
sir.
Yes.
All right, if there's anyone that's having difficulty seeing the image on the screen, please let us know at the present time. All right, for the record, all of our jurors can see the image on the screen. Mr. Kachergis, you may proceed.
Mr. Griffin, I'm showing you what's been admitted into evidence as Plaintiff's Composite Exhibit 2, and the photograph at the top of the screen here is Exhibit 2A. Who is this in Exhibit 2A?
Cayla?
And do these photographs fairly and accurately depict the condition she was in when you arrived at Memorial Hospital?
Yes, sir.
Who took these photos?
I did.
If you could lean in and repeat that, Mr. Griffin, I'm not sure we picked up your voice.
I did.
And you may be getting emotional, Mr. Griffin, and if that's okay, I understand. But if you can bear with me here a minute. I'm going to scroll through them. The top one's 2A. This is 2B. Whose hand is that in the bottom of the photo?
Cayla?
And was that her effort to try to hold up her head while you were taking the photograph?
Yes, sir.
And this is a photograph 2C. Is that an image of when you said her mouth was busted up? Is that what you're referring to?
Yes, sir.
And specifically here in 2D is not that it's better, but it's a better photo of her injuries. I'm reluctant to use the term better in any of this. But does that depict the way her teeth looked when you first saw her at the hospital?
Yes, sir.
And lastly, Mr. Griffin, and there's another photo here, photo 2E. Ms. Griffin appears to be cleaned up a bit there. Well, one, let me ask you, is that Miss Cayla Griffin?
Yes, sir.
Where was photograph 2E taken?
That's at the dentist's office.
Okay. And when was that taken in relation to the first 4 photographs, 2A through 2D?
That was the next day. We left the hospital and I took her straight to the dentist's office.
Thank you, Mr. Griffin. This may sound like a really dumb question, but I've got to ask. How did seeing your daughter in that way, how did that make you feel?
Pissed.
Angry, another way of putting it?
Yes, sir.
Okay. Could you tell what Cayla was experiencing in terms of pain when you arrived at the hospital?
She was in a lot of pain. Just again, just going in and out, but whenever she would wake up, she would just be in just a lot of pain.
And presumably the hospital was addressing that situation?
Yes, sir.
Okay. Were you present when she was provided medication?
Yes, sir.
And was it pain medication?
Yes, sir.
Did that cause her to go in and out as well?
I would think it did. I mean, I'm sure they probably wanted to just, keep her asleep as much as possible so that she didn't feel the pain.
How long were you at the hospital with Cayla?
We didn't leave until that Sunday afternoon when I took her to the dentist.
Sunday afternoon?
Yes, sir.
Was that a yes, sir?
Yes, sir. I'm sorry. Yes, sir.
Okay. And she wasn't transported to the hospital or she was transported to the hospital shortly after midnight on Saturday, the 17th?
Yes, sir.
And she didn't leave the hospital till later in the afternoon on Sunday, the 18th?
Yes, sir.
And to your knowledge, did they run a series of tests on your daughter while she was at the hospital?
Yes, sir.
Did they give you any what they call discharge instructions or rundown what Cayla's condition is to you when discharging her?
I don't remember other than, just make sure she's taking the medication. The pain is going to eventually wear off and, the medicine's going to, stop or whatever. But, she was going to be in a lot of pain. And I mean, that's pretty much it. Just, I can't remember.
Okay. You were in somewhat of a state of shock yourself?
Yes, sir.
Was that a yes?
Yes, sir.
Okay. Upon being discharged from the hospital, what did you and Cayla do?
We went straight to the dentist.
Okay. If you could maybe lean into your microphone a little bit there so we catch
I'm
you.
sorry. I apologize.
That's quite
We
all right.
left. We left the hospital and I took her straight to the dentist because, I called around to try and just find a dentist because I just didn't want her to see her face and, definitely her mouth like that. So I found a dentist and I took her straight there.
Okay. To your knowledge, had Cayla had an opportunity to look at herself in the mirror up
Not at
until
all.
the time?
Not at all. I would not allow her to see herself.
Was Miss Griffin a lady that took pride in her appearance prior to this event?
Yes, sir.
When you got to the dentist office, what happened?
They were pretty, I mean, they were decent. They were really kind. I mean, they got her in pretty quick because I had called and told them, what happened when I made the appointment. I don't think they were expecting it to be as bad as it was. So they were able to get her in there, pretty quick. And I told them that, I just didn't want her to see her face, if at all possible. Yes,
This
sir.
was on a Sunday.
Yes, sir.
Okay. Did there come a time when Cayla saw herself in the mirror at the dentist office?
I think it was after they put the temporary things on her mouth.
When she got a look at herself in the mirror, how did she react?
She wasn't happy. And I mean, she just broke down into tears again.
And so if you could bear with us here for a moment, Mr. Griffin, did the dentist undertake efforts, I take from your prior answer, that the dentist undertook efforts to repair her teeth during that initial visit?
Yes, sir.
Okay. And as you said, it was some sort of temporary?
Yes, sir.
Okay. Did they tell you what they plan to do for Cayla going forward?
Yes, sir. They were gonna, I had to take her back. I don't remember exactly how many days, but it was a couple of days later because they had to make crowns for her top row of teeth.
And so you had to come back to get another, were those
Yes, sir.
designed to be temporary, or was that a permanent fix?
That was going to be another temporary because it was going to be it was probably another month or so, I think, before she actually got what she has in her mouth now.
What we're seeing on the screen today when Miss Griffin smiled for the jury.
Yes, sir.
Okay. After the events of the early morning hours of February 17, 2018, where did Cayla live going forward after that?
With me.
Okay. Versus the young lady that you raised that had been living with you prior to that event, how was Cayla after that event?
Just wasn't.
Mr. Griffin, do you need a moment to collect yourself?
Mr. Griffin, normally in a courtroom, we have Kleenex and things like that around the courtroom, and we certainly have them in here, but that's not going to help you in a remote courtroom. So are there any Kleenex or anything around that you can locate? Would you like
Yes,
them?
sir. Yes, sir. If you don't mind, please.
Would you like to take a moment to compose yourself?
I'd just rather get it over with.
Okay, well, I'll let you, I didn't know if you'd like to have some Kleenex, or maybe if there's a cup of water or something there where you're located, if you'd like to go ahead and locate that. I'll let you step off the witness stand long enough to locate if you'd like.
If you don't mind, sir.
I don't mind. We'll wait right here for you. You can go ahead and try to locate Kleenex and a cup of water. All right, let the record reflect the witness has stepped down off of the remote witness stand to locate some Kleenex and maybe a cup of water or something to drink. All right, Mr. Griffin, do you have everything you need right now?
Yes, sir.
All right, Mr. Gutierrez, you may proceed.
Mr. Griffin, and I apologize for having to put you through this, but I think the question that was before you, before we took that brief recess, was what did you note or observe about your daughter after the events of February 17, 2018 versus the daughter you knew prior to that date?
It just wasn't the same. I mean, she's just not really wanting to go out a lot, sleeping all the time, just totally not the same person.
And is that more in a psychological sense or in a physical sense?
Definitely psychological. I mean, she just was not that just that happy kid. I mean, and I know she's not a kid, and but just, I mean, she just wasn't the same, and just complaining about her body hurting and just headaches, just stuff that I couldn't take care of.
And we've had some testimony earlier today about Miss Griffin having some pre-existing conditions with anxiety. Did Cayla seek or continue treatment after the events of February 17, 2018?
Yes, sir.
And what do you know about her seeking treatment?
I didn't go into the appointments with her, but I mean, oftentimes I would take her to her appointments.
Did the regularity of those appointments increase after the event?
So to my knowledge, I'm going to say, yeah, they increased because I mean, I'm taking her and I know I wasn't taking her that much before. And you know, I didn't think she was going to the doctor that as much as she started going to the doctor after all of this happened.
In terms of her physical appearance and physical health, when did you start to see Miss Griffin make as best as a full recovery as she could? How long did it take?
I don't know if she's there, but I know I can tell you once she had my granddaughter, you know, that seems to have given her a new spark on life.
And congratulations on that front as well. How long was Miss Griffin? I take it Miss Griffin didn't go back to work at Paradise after this. Is that fair to say?
That's fair.
Okay. She didn't return.
No, sir.
Okay. How long was Miss Griffin out of work after this event?
At least a year.
If you could,
Damn, she stayed with me, and it was at least a year. I'm thinking close to it, and then I finally was able to just convince her to go to school. I mean, I have benefits that she can use, and I was finally able to just talk her into just exercising some of those benefits. Just use it to really do some other things now.
and did she return to school?
Yes, sir.
Okay.
Yeah, she's still in school. She's in school now.
I understand. She's also working now, is she not?
Works full time, goes to school full time mom.
And how's she doing in those spheres, if you will?
Definitely the work and the being a mom is probably coming pretty easy to her. I think she has a few challenges with a couple of those classes, but overall, I mean, she's handling it.
How do you feel about the direction your daughter's now taken in her life?
I love it. Yes. Yeah, I love where she is now.
Do you perceive that she's still affected by this event?
I would say that she is. I'm no professional. I mean, I'm a professional parent. So as a professional parent, I think she is.
How do you notice that? What do you observe that causes you to have that belief?
I think sometimes Cayla wears a mask, not a real mask, but she still has those down moments. I see her really probably sometimes even overboard to make sure that she looks good. And, and I tell her, you're beautiful. You don't, she's constantly picking at the little scars in her face. And I tell her, nobody sees that. And, Dad, they do see it. And I get tired of having to explain to people, what happened. Nobody should have done this to me. So, and, even, as a dad, sometimes, we don't have just how would you say, our relationship isn't just straight roses every day. And so sometimes, if things are not going great with us, just some of the stuff that I know she'll say, and I know it's not her. She says things sometimes out of anger. And then she reverts back to, well, you don't understand. I'm the one that got beat up. And, she goes back to that moment.
And does that continue currently?
Yeah, it does. And, I just have to remind myself of, I guess, being, how you say, empathetic to what she's gone through. And it's hard sometimes.
I apologize if I asked you this already, but when she was after the events or the event and she was living with you, did there come a period of time where you could tell that the physical pain had dissipated?
Yeah, I mean, I can't put a date on it, sir, but yeah, at some point, it wasn't as bad as it was.
About
At least
how long?
I don't think so. I mean, I can remember, it just popped into my head. I can remember when she was, going back and forth to school. Some days, she would say that, her body still hurt. And, so that had to be well into this time last year, a little before this time last year.
When she started up at school again?
Yes, sir. I mean, she had started school. So I can recall there were times when she would, go to school, or prior to going, she was like, Dad, I'm just in so much pain. And I guess I'm kind of guilty. I say I tried to be empathetic and even sympathetic, but, there are probably times that I may have, fueled her and, oh, Cayla, you're fine. There's nothing wrong with you. And, and looking back in hindsight, Cayla, I apologize, but I just didn't really think. Sometimes I probably didn't think enough into it, to the fact that she could really still be in pain. I can't tell her how to feel. I can't tell somebody how they really feel on the inside.
Sounds like a little bit of that Marine Corps training.
And that's probably what it was. And I mean, it wasn't a good thing to do.
What is your ambition for your daughter going forward, Mr. Griffin?
I would love to see her stay on the path that she's on. And I think I'm pretty certain she's going to do that, because she realizes, it's not just her. She has a beautiful daughter to take care of. She knows that her mom and I, and, just family and friends, we're going to give her whatever support she needs. I mean, we're here for her, So I just want to see her continue to go where she's going, and just continue to make great strides with her life, as she's shown that she's capable of doing.
Thank you, Mr. Griffin. Your Honor, I have nothing further.
All right, thank you, Mr. Kaczurgas. I'll turn my attention to the members of the jury at this time. Same procedure as before. Do any of you have any questions of the witness, Mr. Griffin? If so, please raise your hand so that we know that you have a question. Then you can go forward and type out your question using the court technology. Does anyone have a question? If so, please raise your hand. All right, I see no jurors with a question for Mr. Griffin. Is that correct? All right, go ahead and unmute your microphones. Does anyone have a question for Mr. Griffin? I just want to make absolutely sure. Does anyone have a question for Mr. Griffin?
No, sir.
No, sir.
No, sir.
Thank you. Let the record reflect that all of our jurors have answered no to that question. There are no juror questions of Mr. Griffin. So, Mr. Kaczurgas, at this time, have you completed your questioning of Mr. Griffin?
I have, Your Honor.
May Mr. Griffin be excused?
He may.
All right, Mr. Griffin, you may use the option on your screen to leave the meeting at this time. And thank you so much for being here, and have a good rest of your day.
Thank you, sir.
Thank you. All right, Mr. Kaczurgas, do you have any other witnesses to call at this time?
I do not, Your Honor, and it's my intention to review some of the exhibits that were previously admitted in the closing argument.
All right, and are you Do you want to review any of those exhibits with the jurors now or publish them before you rest your case?
I think I'd like to publish a few, and if I may speak as I do so, just to identify what we're looking at.
You may.
Okay.
And just once you get it on the screen, then let me know and I'll check with the jurors, see if they can see it.
Very good.
And while you're doing that, ladies and gentlemen of the jury, I'm going to give you an instruction regarding redactions. And you may note some redactions or deletions from some of the documents that are placed in evidence for your consideration. Either they may be on the screen with redactions, or when you go back to the jury room and deliberate, you may notice there are some redactions or deletions from certain documents or records. Under our law, only certain evidence may be considered by a jury in determining a verdict. You are instructed that you must not speculate or even discuss possible reasons for such redactions or deletions. Mr. Kaczurgas, anything you want to put on the screen?
Yes, sir. If I may, permission to publish page 31 of Exhibit 3, medical records from Memorial Hospital.
All right.
And if I may ask whether this is before the jurors on the screen?
All right, ladies and gentlemen of the jury, can you see Exhibit 3, Bates number page 31 that's on the share screen at this time? Please unmute your microphones.
Yes, sir.
Yes.
Yes.
It's pretty small.
It is small.
It is small. Agree.
Right, so everyone can see it, Mr. Kaczurgas, for the record, but it appears that they need to have it enlarged in order to follow along with the highlighting.
And I think they will have the ability to do that when the evidence is submitted. I'll see if I can do that.
I believe there may be a way to annotate that and blow it up for the jury.
Your Honor, if I may, Mr. Kaczurgas, the plus and minus towards the middle of that toolbar, you should be able to enlarge.
All right, thank you, Mr.
Oh,
Muse.
very good. Thank you, Mr. Muse. Ladies and gentlemen of the jury, as I said, this is page 31 of.
Hold on a second, Mr. Kaczurgas. Can you, ladies and gentlemen of the jury, is that large enough or do you need it to be blown up a little more? I know everyone's got a different device.
A little
a
bit
little more.
larger. Yeah.
Oh yeah, the request is to make it a little larger.
How's that?
Ladies and gentlemen of the jury, is everyone okay with that? If there's anyone that still needs it blown up a little larger, please verbally let us know. All right, hearing no response from the jury, I'll assume that this is large enough. Mr. Kaczurgas, you may proceed with your publishing.
What I'm bringing up on the screen here is one of the entries from her assessment upon arrival at Memorial Hospital with a pain scale rating of 8, indicating severe pain.
All right.
Next, I'd like to review some findings from, this would be from what's known as a CT scan of the facial bones. And can everyone see the document?
Ladies and gentlemen of the jury, is that large enough or do you need it enlarged a little bit larger? Can everyone see it and read it?
I can
Yeah.
read it.
I can see it.
Yes.
And
If there's anyone that's having difficulty, please let us know at the present time.
And what you'll see here is findings of the CT scan of facial bones with coronal and sagittal reconstruction without contrast. And the findings are mildly displaced right medial orbital wall fracture, partially minimal displaced right orbital floor fracture. And then the impression is the same, right medial orbital wall and orbital floor partially displaced fracture and deformities. Next will be a CT scan of the brain
Mr. Kaczurgis, hold on a second. We've got a juror that's missing from the screen. I noticed when you had that exhibit up, juror number 1, Miss Burns was missing from the, there she is. She's back on the screen. Miss
Sorry.
Burns, did we lose you for a moment or was it just your video?
No, you lost me. Sorry.
Okay, let's do this, Mr. Kaczurgis. I don't want Miss Burns to miss the exhibit. I'm assuming you didn't really see the exhibit that was up on the screen.
She's frozen on my screen right now.
Okay,
Your Honor.
Ms. Burns, you're frozen. Mr. Muse, is this something we're gonna have to address in the jury room?
Your Honor, if she's not here, we're not going to be able to get her into the remote jury room either.
Why don't we do this? I'm gonna send you all. We've been going for about an hour, a little less than an hour. So what we're gonna do now is we're gonna take a Mr. Muse. Would 10 minutes be enough time?
Yes, sir, that should be sufficient.
All right, we're going to take a 10-minute recess here to get the technology squared away. And I do appreciate everyone's patience. So Mr. Ashley, if you could put the screen up that we're in a short recess for 10 minutes and all of you are going to go back to the jury room with Mr. Muse and we'll get all the technology squared away and we'll come back in 10 minutes. During this recess, if Mr. Muse doesn't need you to be back on the screen, you're free to get up and walk about, move around. You can check your devices. You can check on other people in your household and check in with work and what have you. But you can't discuss this case or the people or places involved in this case. And you obviously can't do any research about this case or people or places involved in this case. And as I was giving that instruction, juror number 1, Miss Burns, appeared again. Miss Burns, do you feel like you can see us and hear us now? All right, you're muted.
Yes, sir.
Okay.
Sorry.
That's okay. Please don't apologize because I may be the next person to have an issue technology wise. So please never apologize. It's always my responsibility to make sure everything's working properly. So let me ask everyone else this because we may not need to take the recess unless someone really needs one. Can everyone else hear me and see me?
Yes.
Yes.
Mr. Kaczurgis,
Yes.
go ahead. Are you ready to proceed, Mr. Kaczurgis?
I am, Your Honor.
Can everyone hear and see Mr. Kaczurgis?
Yes.
Yes.
All right. And so what I'm going to ask then is let's go back to that exhibit, Mr. Kaczurgis, the one that you had on the screen before we lost Miss Burns. I believe that was exhibit 3 as well. Or was it exhibit 4?
These are excerpts out of Exhibit 3, Your Honor.
Okay, exhibit 3. So let's go back to that page about, I believe it was the CT results, if I'm not mistaken.
I believe this is the one to which I was referring when, like myself at some point today, we had some connectivity issues, and that's quite all right. It happens to the best of us. And what we were highlighting, Ms. Burns, was the mildly displaced right medial orbital wall fracture and partially minimally displaced right orbital floor fracture, which is repeated here in the impression section.
Let's go ahead and share that screen again so Ms.
Oh, I'm
Burns
sorry.
can follow along. It's not on the screen, so let's put it back on the screen. I'll check with all the jurors,
I
make sure they can
apologize.
see it.
As I said, it happens to the best of us. And I'm
right,
publishing that CT report here, which can be found at page 84 of Exhibit 3.
All right, so I'm gonna ask all our jurors again, can all of you see the exhibit that's being shared on the screen? And if so, is it enlarged large enough for you to read the type on it?
I can
Yes.
read it.
Yes, sir.
All right, if there's anyone that has difficulty seeing it, please let us know at this time. For the record, no one's responded, so for the record, everyone can see the exhibit. Is there anything other than that highlighted portion that you want to share with the jury, Mr. Kaczurgis?
No, Your Honor.
All right, Ms. Burns, have you had an opportunity to read it? Okay, I see her nodding her head, yes.
And next, this will be out of Exhibit 3, page 81, and it will be a CT scan of the head without contrast. And if I may publish.
You may.
And in this record, as I said, it was page 81 of Exhibit 3.
Mr. Kaczurgis, let's hold on a second. I want to confirm with the jurors that they can all see the exhibit and that it's enlarged large enough for each one of them with their devices to read it. Can everyone see the exhibit, number 1? Number 2, is the type on the exhibit blown up large enough for you to read the highlighted portion? Yes or no?
Yes.
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 Yes, sir.
Yes.
All right, if there's anyone with a different answer than the majority, please either raise your hand or say something audibly so we can know. All right, for the record, no one's raised their hand or indicated otherwise, so you may proceed with the publishing, Mr. Gutierrez.
And the impression here, fortunately, there was no intracranial bleeds or mass effect. However, this CT scan did confirm once again a right medial orbital wall fracture with associated right intraorbital gas. Orbital floor fracture cannot be excluded. And so while that could not be determined from the CT scan of the brain, a CT scan of the eye was performed. Bear with me. Or a CT scan of and bear with me. My permission to publish, Your Honor.
All right, what page and what exhibit?
This would be Exhibit 3, pages 25 and 26.
All right, you may so publish.
And before us on the screen, and I'll try to blow this up, is you can see here there's a CT scan of the maxillofacial without contrast.
Hold on a second, Mr. Gutierrez. Can all the members of the jury see the exhibit on the screen, and is the type enlarged large enough for you to follow along with Mr. Gutierrez? Yes or no?
Yes.
Yes.
All right, if anyone has an answer different than the majority, please let us know. So for the record, I don't see any response, so all the jurors can see the exhibit. You may proceed, Mr. Gutierrez.
And going over to page 26, and you'll have the benefit of these records back in the jury room, but you'll see on the impression that there was a right medial orbital wall and orbital floor partially displaced fracture deformities, associated pre and post septal right orbital gas. Once again, confirming the orbital wall and orbital floor fractures. And then in terms of the Miss Griffin's treatment at the hospital, we have on page, I believe it's 27.
Are we still on exhibit 3?
This will be exhibit 3, excuse me, page 17. And permission to publish.
All right, you may so publish.
This is when Miss Griffin was at Memorial Hospital, and I'll try to blow this up so that you can see.
All right, ladies and gentlemen of the jury, can you all, number one, can you see the exhibit? And number two, is the type large enough for you to see it? Is it enlarged large enough for you to follow along? Yes or no?
Yes.
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 If anyone has an answer different than majority, please let us know. I see no indication of anything to the contrary, so all the jurors can see the exhibit. You may proceed, Mr. Gutierrez.
When Miss Griffin first came into the hospital and was assessed, you can see she was assessed with what is labeled SP assault, status post-assault, with also a concussion, and as we've discussed, the right medial orbital wall fracture, and a condition denominated cervicalgia. And then the plan talks about getting the CT scans that we had just reviewed. You'll also see in this entry toxicology, and there's alcohol. You'll have the benefit of a full tox screen later that is negative for all drugs of abuse as well as any other controlled substances. But the alcohol quantitative, and that's mg/dl, milligrams per deciliter, and it's got a reading of 66. And for those science and math majors out there, when you do the math on a milligram per deciliter, that will be consistent with 0.066, or if you wanted to round up, 0.07. We'll save that for later. When Miss Griffin went to ASAP Dental Care, if I could, I'd like to publish a record out of Exhibit 5, the ASAP Dental records, and specifically pages 2, 3, and 4. Permission to publish.
You may so publish.
This is the treatment notes from ASAP Dental Care. And as you will
Mr.
see, I'll
Gutierrez,
try
we
to-
may need to blow those up a little bit. Enlarge them.
doing my best.
All right, that's good. It looks like you're making progress. So ladies and gentlemen, the jury, number one, can you see these dental records? And number two is that it has Mr. Gutierrez enlarged it enough to where you can follow along with the type.
Yes.
Yes.
All right, is there anyone with an answer different than the majority? If so, please raise your hand so we can get it fixed. All right, for the record, all of our jurors can see the exhibit. You may proceed, Mr. Gutierrez.
As you'll see, this is the date, February 18, 2018, that Sunday following the incident. And she was being examined for teeth 7 through 10, which are her front teeth. And when they're evaluating her, there's the statement in the chief complaint. I was beaten up last night by my boyfriend and now my front teeth are cracked. And I'll reserve argument on that for closing argument, but that's clearly not what happened. However, they do note that when they were going through it, that she had fracture lines along teeth 7 through 10, and you've seen the photos of those front teeth. And they're recommending crowns within 2 weeks to test for vitality and to make sure teeth will stay vital. And the diagnosis is enamel and dentin fracture on teeth 7 through 10, crowns recommended. And when they talk about treatment today, there is a maxi temporary for aesthetic concerns, a temporary fix, if you will, but the patient could not tolerate further treatment on that Sunday afternoon at 2 in the afternoon. Ms. Griffin comes back into ASAP Dental Care a few days later on February 20th, 2018 at 6:30 in the evening, 2 days after that initial visit. And they did what's called crown prep of those same front 4 teeth. And what they do on that date is put in a temporary crown cemented into that tooth for those 4 teeth. Another more permanent, yet still a temporary fix. They also took molds, as you will see here, for the pre-op impression, and then final impressions were made of the teeth for the temporary crown, as well as to put in permanent crowns later, which you will see that they did on March 25, 2018, a little over a month later. She came in at 10:40 or so in the morning and presents for final cementation of the crown to tooth 7 through 10. Presented in a good form, and that's what they did is they put in permanent crowns on the teeth 7 through 10. And she tolerated that procedure well, and then returned on April 6, 2018 to make sure that the crowns took, x-rays were taken, and they were in there for approximately 2 weeks and provided restorations needed per the treatment plan. And so if we go to the treatment plan, here's the
Okay,
treatment.
what pages are we on, Mr. Katsouris?
This will be page 29.
So we're still on Exhibit 5, page 29.
29, yes, sir. And when you
Right,
look
ladies
at
and gentlemen of the jury, can you all see the exhibit, and has it been enlarged to where you can see it? Any yes or no?
Yes.
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 All right, if anyone
Yeah.
has trouble seeing it, please raise your hand or say something to indicate otherwise. And it appears that all the jurors for the record can see the exhibit. You may proceed, Ms. Katsouris.
and you will see that according to the treatment plan, those were 4 visits that Miss Griffin had, and they've recommended another 5th visit to do comprehensive oral evaluation as well as some more full mouth images that, per the records, have yet to be performed but are recommended to take place in the future with that cost associated with it. However, regarding the ASAP dental dental notes, or bear with me. You will see in Exhibit 5 the billing records for Miss Griffin, and these will be located at page 5 of Exhibit 5. And if I may publish,
You may publish.
you will see the patient ledger.
Hold on a
And
second, Mr. Katsouris. Ladies and gentlemen of the remote jury, can you all see the exhibit number 1? And is it enlarged, large enough for you to be able to follow along and read the type? Yes or no?
Yes.
Yes, sir.
All right, if there's anyone that's answered differently, majority, please raise your hand or give us a verbal response. For the record, no one has raised their hand or given us a response. So all members of our jury can see the exhibit. You may proceed, Mr. Katsouris.
And then looking at the patient ledger, which is page 5 of Exhibit 5, in reviewing this, you will see 3 entries out to the right of the page: a charge, a payment, and a balance. The payment is the actual charges that were incurred for her dental expenses, and you'll all have the ability to calculate these in the deliberation room, but to try to save you some effort on that, my math would reveal a total that was expended for this dental care without the 5th visit that is recommended at $4,749. Likewise, when we look at the billing records of Memorial Hospital, and these will be found at Exhibit 6, and if I may publish, Your Honor.
You may. What pages are you going to publish?
This is page 5, 6, and 7 of Exhibit 6. And permission to publish?
You may so publish. All right. Ladies and gentlemen of the jury, can each of you see the exhibit on the screen, and is it enlarged large enough for you to be able to follow along and read the type? Yes or no?
Yes.
Yes.
Yes, sir.
All right, if there's anyone with an answer different than the majority, please raise your hand or give us some audible or verbal response. Seeing none, the court finds that all the jurors can see the exhibit. You may proceed, Mr. Katsoukas.
And these compile the entries for the care provided and the line item costs for this care, and you'll have the benefit of this in the jury room. But this would be the first page of, in essence, her medical bill. And if we could look at the second page, this will be page 6 of Exhibit 6. And permission to publish.
You may so publish.
You will see, well, I hope you will.
All right, ladies and gentlemen of the jury, the image is on the screen. Can all of you see that exhibit on your screen, and is it enlarged to the point that you'll be able to follow along and read the type that's been highlighted? Yes or no?
Yes.
Yes.
All right, does anyone have an answer different than the majority? If so, please raise your hand or give us an audible or verbal response. Hearing none and seeing none from the jury, the court finds all the jurors can see the exhibit. You may proceed, Mr. Katsoukas.
And her treatment from Memorial Hospital produced a total of $39,884. And lastly, on page 7 of Exhibit 6, once again, a recap of those billing records. And permission to publish.
You may so publish.
Once again, that total amounted to $39,884 for the total recap of charges from Memorial Hospital. In the course of this treatment, she was also seen by a physician at Memorial, Dr. Richard Beck. And if I can provide you with an excerpt from Dr. Beck's records, which are contained at Exhibit 4. And this will be at page 2 of Exhibit 4, Dr. Beck's records.
All right, you may so publish.
Well, there is a charge of $200.
Well, hold on a second, Mr. Katsoukas. Ladies and gentlemen of the jury, can you all see the exhibit on the screen, and is it enlarged to the point that you can follow along with the text that's on that exhibit? Yes or no?
Yes.
Yes.
All right, if there's anyone with an answer to the contrary, please raise your hand or give us a verbal response. Hearing none and seeing none from the jurors, the court finds the jurors can see the exhibit. You may proceed, Mr. Katsoukas.
There's a bill for Dr. Beck for $200. And I believe that's all I have for right now, Your Honor.
Is that all the publishing of the exhibits at the present time?
Yes, sir.
All right, is the plaintiff going to rest at this time?
Plaintiff rests.
All right, ladies and gentlemen of the jury, the plaintiff has rested her case, and so we have been going for right at about an hour and 10 minutes or an hour and 15 minutes since we came back from the lunch recess. This is a good natural point to take a 10-minute comfort break, and so during this comfort break, you're not to talk to anyone about this case or people or places involved in this case. You're also not to talk to each other about this case or the people or places involved in this case. You'll be retiring to the jury room and you'll be in recess for 10 minutes. You're free to power up your devices. You can power up the devices you powered off before we started. You can do whatever you normally do on those devices, text, call, email your friends, family, coworkers, anyone that you want to talk to about any topic in the whole wide world, except for this case or people or places involved in this case. If some of you are multitasking today and you have work and other obligations that you need to use that device that you're using right now to do other things, you're free to split your screen. Don't leave this meeting, don't leave this remote courtroom, but you're free to split your screen and do other things on that screen, whether it's answering email, checking out social media, doing work-related activities, anything of that nature you're free to do. You're also free to take care of any personal tasks that you have to take care of in your house or at your office, work-related tasks. You can get up and leave. You can turn off the video, but before you leave, Mr. Muse is going to send you an invitation to go to the remote jury room so that you leave the remote courtroom during this 10-minute recess. And when you come back from that recess, they're going to just make sure that all the technology is connected, everyone can hear and see and all of that before we bring you into the courtroom. And when you come back, I expect that we're going to be somewhere around an hour or so between closing arguments and my final instructions. So that's my best estimate. And then you'll go back to the remote jury room and you'll see the third Zoom tutorial, part 3, so to speak, about Zoom skills you'll need to deliberate. So that's what's coming ahead. That's what I'm projecting ahead in terms of our schedule. And like I said last week, once you are in deliberations, that can be as long or as little time as necessary to review all the evidence and testimony and come up with a unanimous verdict. So with that in mind, you're going to get an invitation from Mr. Muse to go to the remote jury room, and Mr. Ashley's going to put up our short recess slide with 10 minutes on it, and we'll be in recess for 10 minutes. Mr. Muse, anything further I need to advise the jury?
No, Your Honor.
And Ms. Hodak, as our special magistrate, anything else I need to advise the jury before they leave for their 10-minute recess?
No, Your Honor.
I do want to say one thing. This is for all of you. When we take a 10-minute recess, please check that clock periodically because we don't want you to disappear and we can't find you because that's going to delay us coming back from the recess. So we'll be in recess here for 10 minutes. Please accept that invitation to go back to the remote jury room. Thank you.
All right, Your Honor, all jurors have entered the remote jury room.
All right, thank you, Mr. Muse. We're in recess for 10 minutes. All right, let's get Mr. Kaczurgas and his client back in the courtroom. We're not on the record yet. We have the court reporter here as well. We're ready to go back on the record then if our court reporter is ready. Are you ready, Madam Court Reporter? I see you're ready. All right, we'll go back on the record then in the case of Griffin versus Albanese Enterprise, Inc., doing business as Paradise, 2019 CA 1555. Let the record reflect that Mr. Kaczurgas, plaintiff's counsel, along with his client, the plaintiff, Ms. Griffin, are present along with our special magistrate, Ms. Hodak, our remote jury bailiff, Mr. Muse, and the court reporter is recording these proceedings as I speak. All 8 of our jurors are in the jury room waiting to come back into the courtroom. Is that correct, Mr. Muse?
Yes, Your Honor.
All right. So from a technology standpoint, are they all connected? Everything's functioning properly?
Yes, sir. Just give me a moment. I'd like to just pop in and talk with remote bailiff Patrick to make sure that there's no other issues going on.
Right. We're not going to do the Zoom tutorial part 3 until after they're back there after all the closing arguments and instructions.
Yes, sir. Bear with me.
All right. So while he's in there, we have a couple of matters to address in here. So first of all, while Mr. Muse is going back there, this is a point in the trial where I like to confirm who our alternate jurors are, because when we get done with all the instructions and the argument, at that point, after all the instructions are done, that will be when I excuse and discharge our alternate jurors. So for the record, I have written down that our first alternate juror was juror number 7, Nathaniel James. And then I had as our second alternate was juror number 8, Miss Joyner Rogers. Mr. Kaczurgas, is that who you have as our alternates?
I do, Your Honor.
Okay, so I will be excusing them and discharging them at the end after all my instructions are given. And so this is my procedure in an in-person trial. In an in-person trial, I let them go back to the jury room, gather their belongings, and then they can either leave and go home, which I think everyone has always done that, with the exception of one case I can remember. But of all the cases I've tried as a judge, there was one case where some jurors wanted to wait in the gallery to observe what the outcome was going to be, and I'm perfectly happy to allow that. But obviously, with a remote trial, we don't have an in-person courtroom for them to go to. So the alternative would be, if either or both of the jurors would like to observe the rest of the proceedings, would it be possible to send an invite to those jurors to then go to the gallery where the observers are to watch the rest of the proceedings? Is that possible, Mr. Smith?
Yes, sir. We can basically, if you want the ceremonial act of putting them into the waiting room and bringing them back, that's fine. Or we can just ask them to turn off their microphone and video, and they would be in the room just like the other folks that are non-participants right now. They wouldn't be on the screen anymore.
Okay, well, I think that we don't have to do anything ceremonial. It'll just be an acknowledgement that they're going to stay. I'll have them tell me if they want to stay or leave. If they want to leave, obviously they just leave the meeting with our collective thanks. I will tell them, I always instruct the jurors not to discuss the case until after they know there's been a verdict. I also ask the jurors if they would like to know the outcome of the trial. In an in-person trial, have them let the bailiff know when they gather their belongings in the jury room. But since we don't have that scenario here, what I'll do is I'll ask the jurors if they want to know the outcome of the trial to let us know now, so I can know that one of us are going to need to reach out to them after there's a verdict to let them know the outcome. So that's the way I'm going to handle it, unless there's any objections from anyone or a better suggestion.
No, sir. And they all have my contact or James's contact information from the very beginning of this.
Okay,
So
what I'll do is I'll tell them to reach out to you after you all after this is over to find out the verdict.
okay.
All right. Mr. Kaczurgas, any objection to my handling the two alternate jurors in that way?
No, Your Honor.
Right, so when they come back in, we're going to be at a stage where I'm going to be doing the final instructions. I have them in front of me. Mr. Ashley, do you have them ready to put on the screen when they come back in? Okay, so I will be doing those instructions up to the point where we go to closing arguments. When we get to that point, Mr. Kaczurgas, that'll be your cue. And I will give them a brief instruction about closing arguments that what you say is not evidence for the law. And then I'll ask you if you'd like to give a closing argument to the jury, and you'll say yes, and then you'll proceed from there. And then when you're done, I have those brief Section 700 closing instructions. And when I'm done with that, at that point, I'll discharge the alternate jurors. At that point, after they're discharged, we know if they're going to stay or leave. And I do what I just said earlier, then the jurors are going to go back into the remote jury room. They'll accept the invite. When they go back there, I'm going to tell them before they leave that their first job is to watch the tutorial part 3, the PowerPoint tutorial part 3 on Zoom skills needed for deliberations. And when that's done, they're going to be picking a 4-person on the case. And when they pick the 4-person, they have to hit the help button so that our remote jury bailiff knows to go back in there and find out who the 4-person is and come back out. And that signals us that it's time to drop box the exhibits into the jury room and what we talked about before the lunch recess. So with that in mind, while they're getting the Zoom tutorial on skills needed for deliberations and picking a 4-person, Mr. Smith, do we have someone out here who can work with Mr. Rogerson, our deputy clerk, and Mr. Kaczurgas in the court, and our personnel to confirm the exhibits that are to be drop boxed along with the instructions are the right ones? Do we have someone from your staff, Mr. Smith?
Yes, sir. If the only thing I ask, Your Honor, is that if the clerk or the attorney does not have the link that they've had all along, I'll be more than happy to get it to them, but I do not want to run it through here.
No,
But I can go to them in a meeting room if you want and discuss, make sure everything's in there that needs to be.
well, what we can do then is we can go in the into the plaintiff's attorney conference room. So you all will go into the remote attorney conference room. The remote deputy trial clerks, Mr. Smith, you all will go in there to review. And I don't need to review the exhibits. I just want, when you come back out, I'm going to ask you all, each one of you, Mr. Rogerson, Mr. Kaczurgas, Mr. Smith, to confirm for the record that the exhibits that are going through Dropbox into the jury room and the jury instructions I gave you previously are the correct items to go into the jury room via Dropbox. I'm just going to get that verbal confirmation. I don't need to go through all that on the share screen, all that. Just want your verbal confirmation.
Yes, sir.
Okay. And the instructions that are going back in Dropbox are going to be the same ones I'm reading. They're going to be scrolled on the screen. All right. Anything else we need to address housekeeping wise? So when they come back, when they pick the 4-person, all that stuff's going to be, by that time, hopefully we've got it confirmed that what's going back there will be Dropboxed in. Mr. Muse will make one final stop in there to make sure that they received everything in Dropbox and can access it. When he exits, the deliberations begin, and they'll know to hit the help button if they either have an inquiry, a question, or meaning a request or a question. And they're going to be told how to fill out those forms, the verdict form and the juror inquiry form. They're going to be told how to do that in the Zoom tutorial that we've already reviewed previously. And then they'll go from there. So we'll just be waiting at that point. Anything else we need to address housekeeping wise before we bring our 8 jurors in?
Your Honor, I have the plaintiff's father in the waiting room. Is it okay to allow him to watch the rest of the proceedings?
Any objection, Mr. Kaczurgas?
No, Your Honor.
All right, so he will be permitted to go into the to actually observe like the media and the other persons that are watching. He just has to have his video and his audio off. We don't want to see him or hear from him, and so he'll need to make sure and have all that off.
All right, I'm going to admit him now, and I can turn off his video and audio for him.
All right, very good. Thank you.
And Your Honor, if I'm publishing to the jury some excerpts of exhibits or exhibits in closing argument, would you like me to identify for the record where exhibit, page number, all of that stuff?
I think that's good because some of the jurors are taking notes. I can see them writing. Hopefully that's what they're writing down. They're taking notes. So if they are, then they may want to jot down what page you're referring to, the Bates number page and all of that. It'll help them if you refer to it that way. And also, unless you want me to interject, every time you do it, it kind of chops you up. If you want to do ask the jury if they can see it, see the exhibit, and if you need to do anything to it, if you want to handle that, you can, or if you want me to handle it, I will. I know it's kind of cumbersome, but I want to make sure the jurors can see it.
I think I'd prefer to handle it and
Okay.
probably do it by, for some reason you can't follow me or see something, please raise a hand and we'll try to make sure that you get it.
All right, fine. That'll work out just fine. All right, anything else?
No.
All right, I think we're ready to go. And Mr. Muse, are all 8 jurors in the jury room ready to come back in?
Yes, Your Honor.
All right, you can go ahead and bring all 8 of our jurors in.
Your Honor, all 8 jurors are present and accounted for in the remote courtroom.
All right, thank you, Mr. Muse. Welcome back, ladies and gentlemen of the jury. We're close to my estimate on the recess time, and so as always, I do appreciate your patience as we work through the process of the very first remote civil jury trial. And so we're at that stage of the case where I have some instructions to give you. There'll be some closing argument by Mr. Gachurgas and then some final closing instructions by the court after he's done with his argument. So I do need you to listen very closely to these instructions. These do come from the Florida Supreme Court, and for the record, I have made a few modifications to these instructions to fit a remote trial. And so these are very slight modifications. And so what's going to happen now is Mr. Ashley, the remote bailiff, who's actually the only person in the physical courtroom with me, will share screen on those instructions and put them on the screen. And so Mr. Ashley, go ahead and do that at this time. So ladies and gentlemen of the remote jury, can you all see those instructions that are on the screen?
Yes.
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 All right. If there's anyone that's having trouble seeing those instructions, please let me know. Hearing and seeing no sign from the jury, all the jurors can see the instructions. And also, as I've started out every time, I need you all to turn off any devices that you had on during the recess. I also need you to take down anything off of your screen that could be anything at all, in this case, off your screen. I don't want any split screen. Don't want you multitasking and doing other things. Your entire focus should be on the screen as to this trial and to the audio source of your device to hear what I'm saying. So I've noticed that some of you are taking notes. And that's, as I said at the beginning, that's perfectly acceptable. We encourage note taking, but it's not required. But this is a part of the trial where I can tell you that you don't need to take notes. And you may be saying, well, why not? I love to take notes. It's what I do whenever I'm in a classroom or a place where someone's saying something important. We all appreciate that, but the reason you don't need to take notes is because I'm going to be reading these instructions to you, number one. Number two, the instructions are going to be on the screen for you to see as I read them. And there are studies that show that when you see something and hear something at the same time, that generally you remember those more than you do if someone just read it or it was just on the screen. And if you're still feeling concerned that you won't remember what I'm going to be reading to you in terms of the instructions, you can relax, because these very same instructions that are on the screen right now will be available for each of you via the Dropbox when you're deliberating in the remote jury room. So each of you will have access to these very same instructions to review if you see fit. So with that in mind, I'm going to begin reading to you the instructions, and please listen very carefully. Personal injury and property damages introduction. The court has determined and now instructs you that the defendant, Albanese Enterprise, Inc., doing business as Paradise, was negligent. A default judgment has been entered against the defendant. Mr. Ms. Griffin is therefore entitled to recover from Albanese Enterprise, Inc. for the loss or damage or injury as shown by the greater weight of the evidence to have been caused by Albanese Enterprise, Inc. doing business as Paradise. The issue you must decide is the extent of losses, injuries, or damages suffered by Ms. Griffin. You should award Ms. Griffin an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for her injury, including any damage she is reasonably certain to incur in the future. You shall consider the following elements: injury, pain, disability, disfigurement, loss of capacity for enjoyment of life. Any bodily injury sustained by Ms. Griffin and any resulting pain and suffering, disfigurement, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. Medical expenses. The reasonable expense of hospitalization and medical care and treatment necessarily or reasonably obtained by Ms. Griffin in the past or to be so obtained in the future. Any amount of damage which you allow for future medical expenses should be reduced to its present money value, and only the present money value of these future economic damages should be included in your verdict. The present money value of future economic damages is the sum of money needed now, which together with what that sum will earn in the future will compensate Ms. Griffin for these losses as they are actually experienced in future years. Greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Redaction instruction. You may note some redactions and or deletions from some of the documents placed in evidence for your consideration. Under our law, only certain evidence may be considered by a jury in determining a verdict. You are instructed that you must not speculate or even discuss possible reasons for such redactions and or deletions. Collateral source rule. You should not reduce the amount of compensation to which Ms. Griffin is otherwise entitled on account of medical insurance payments which the evidence shows she received from her insurance company. The court will reduce as necessary the amount of compensation to which Ms. Griffin is entitled on account of any such payments. Weighing the evidence. In deciding this case, it is your duty as jurors to answer certain questions I ask you to answer on a special form called a verdict form. You must come to an agreement about your verdict. Your agreed upon answers to my questions are called your jury verdict. The evidence in this case consists of the sworn testimony of the witnesses and all exhibits received in evidence. In reaching your verdict, you must think about and weigh the testimony and any documents, photographs, or other material that has been received in evidence. You may also consider any facts that were admitted or agreed to by the lawyer. Your job is to determine what the plaintiff, Ms. Griffin's damages are, and you may use reason and common sense to reach your conclusions. You may draw reasonable inferences from the evidence, but you should not guess about things that were not covered here. And you must always apply the law as I've explained it to you. Believability of witnesses. Let me speak briefly about the witnesses. In evaluating the believability of any witness and weight you will give the testimony of any witness, you may properly consider the demeanor of the witness while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness considered in the light of all the evidence in the case and in the light of your own experience and common sense. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would have given if called to the courtroom. The witness should not be discredited just because the witness talked with a lawyer about his or her testimony. That is the law that you must follow in deciding this case. The attorney for the plaintiff will now present his final argument. When he is through, I will have a few final instructions about your deliberations. Mr. Kachurgis, as counsel for the plaintiff at this time, are there any exceptions or objections to the instructions I've just given to the jury? You're muted, Mr. Kachurgis.
No exceptions or objections, Your Honor.
All right, and ladies and gentlemen of the jury, the plaintiff's attorney will now present his final argument. Please remember that what the attorney says is not evidence or your instruction on the law. However, do listen very closely to his arguments. They are intended to aid you in understanding the case. Mr. Kachurgis, would you like to proceed with your closing argument?
Yes, Your Honor.
All right, you may proceed.
May it please the court.
You may proceed. And Mr. Ashley, you can take down those jury instructions for the present.
Ladies and gentlemen of the jury, I want to thank you for your time and attention here today, as well as last week in jury selection. As I said back then, it's just as true today. We're entering into a brave new world with the COVID pandemic and pushing forward and trying to get the justice system back up and running. Everybody is appreciative of your time, efforts dedicated to this case. Turning to this case, no man should ever lay his hands on a woman, because when that happens, bad things happen. And that's what happened on the early morning hours of February 17, 2018. These two gentlemen, Marcus Brusky, Malcolm George, put their hands on Cayla Griffin. The larger gentleman, about 6'4", 275 to 300 pounds, threw her out in nothing but her attire in the evening. And when she attempted to re-enter the establishment to get her things, what did he do? He punched her in the eye. When she got up, aggravated and hostile about what had happened, his colleague there, Mr. George, punched her in the mouth. Unacceptable conduct. And at the time, Miss Griffin was a young lady, 21 years old. She had graduated from high school, had worked in the service industry in various restaurants, including Ritz-Carlton up in Nassau County, but being somewhat young and petulant, like many 21-year-olds are, she thought the lifestyle of a dancer was something that appealed to her. She could go out and make money, have drinks, party, if you will, and have a good time. But in the course of doing so, she realized that wasn't a good time. That wasn't the thing she needed to be doing with her life. And that got driven home in a horrible fashion on that date. Upon trying to enter the establishment, she got hit with such force that it caused a orbital wall fracture and an orbital floor fracture, what they call a blowout fracture, as you'll see in the records, to both her eyes. With respect to the blow to the mouth, she cracked her 4 front teeth with permanent scarring to her lip. She was beaten to the point of unconsciousness. You'll see in the records she suffered a concussion. You will also see in the records that she was negative for all drugs of abuse and indeed all controlled substances, including benzodiazepines, which she had been prescribed but was not taking at the time. The only thing that you'll find that was in her system was alcohol. And Miss Griffin testified that she believed she had about 4 drinks. When you look at the toxicology report and the evidence in this case, you will see that it comes back with what the math will reveal is a 0.06, or rounded up to a 0.07. So she wasn't intoxicated to the point she didn't know what she was doing. Far from it. According to the medical evidence, she hadn't even reached the legal limit in Florida of 0.08. For whatever reason, Mr. Brusky took issue with Miss Griffin. We know from a prior encounter, he had used some racial slurs against her and obviously was not a fan. That boiled over in that early morning hours, and he took it out with tremendous acts of violence. Miss Griffin was approximately 100 pounds, and there wasn't a whole lot of clothing on her to buffer the blows. But that's what these two gentlemen did. Knocked her straight to the ground, permanently damaging her face, cracking her skull, and cracking her teeth. Fortunately, Miss Griffin has a support group around her and some loving family and parents. And you heard the testimony of her father, Charlie Griffin. And when he arrived on scene, you heard how his demeanor was. To put it in terms more friendly for courtroom proceedings, he was angry about what happened. Indeed, he tried to go after those men. And fortunately for him, police were on the scene. They weren't arresting Miss Griffin, they were separating her from the others at the scene and making sure that she was separated from them so nothing further untoward would happen. As you heard from Mr. Griffin, she wasn't arrested. They were just placing her there. Indeed, she wasn't arrested. She was turned over to the care of the emergency medical technicians and paramedics who transported her to the hospital. And if we can take a look at that for a moment, that's the first document that gets created. And I'm referring to Exhibit 3, Memorial Medical Records, and page 74. And I'm going to publish for you. Usually in a courtroom, we would have PowerPoints all queued up, ready to roll. Because we're using the Zoom platform, it takes a little more time, but we will get there. And what's before you is what they call a run report from the emergency medical technicians. And as you will see, assaulted by bouncer. As you heard from Miss Griffin in her testimony, she had a previous medical history of anxiety, and you'll see the initials ADHD, attention deficit hyperactivity disorder. But she's the history is assaulted by bouncer. And they note a two-inch hematoma to the forehead and laceration to the upper and lower lip. They had administered ketamine in transport to calm Miss Griffin down. She then gets to the hospital and they begin treating Miss Griffin. And I want to raise this with you now. And this is once again in Exhibit 3, page 14. But I found this rather curious when I was reviewing the case. And what you'll see is the initial entry at the emergency department. And I'll try to slide this over so that you can see it a little better. But it's interesting, when she arrives at the emergency medical department, it describes a 21-year-old female with a history of that ADHD and anxiety presents to the emergency department via EMS for assault at work, which occurred prior to arrival. And per EMS, the emergency medical services, the patient worked at a gentleman's club near Bay Meadows, got involved in a fight and became combative when bouncers tried to break up the altercation. The patient sustained injuries to the head and face, supposedly from bouncers. Well, let's take a look at that for a moment. We know from the testimony of Mr. Charlie Griffin that Miss Cayla Griffin was in no way in a condition to provide any information to the paramedics or emergency personnel. She was in and out of consciousness. Why? Because of the concussion that she had suffered at the hands of these gentlemen when they knocked her to the ground. You saw that on one of the emergency department entries upon her presentation. One of the first things they noted, besides a suspected orbital fracture, was a concussion. So there's no way that the emergency medical services acquired this information from Miss Griffin. Well, who does that leave to provide the information? The people working at the gentleman's club. Indeed, the very bouncers that assaulted her. We know for a fact from Miss Griffin's testimony and the nature of her injuries that the injury wasn't supposedly from bouncers, it was indeed from bouncers. You don't suffer those type of injuries, a fractured orbital wall and a fractured orbital floor, without a tremendous violent force being applied to oneself. And in this case, you have an image of that. The 6'4", 275-pound image of Mr. Brusky, who crashed his fist into her face, shattering her cheekbones or her orbital wall and her orbital floor. When she responded in a rush of adrenaline to that blow, his colleague, Ace, jumps in and punches her in the mouth with a ring, cracking her 4 teeth and scarring her lip permanently. So the story that's presented to the emergency department via the emergency medical services is the story that's supplied to them by the bouncers, because it's much more in their interest to be breaking up a fight, which is part of their job duties, than instigating one and causing violence that ends right where we are today, in courtrooms with lawsuits. And in an effort to do that, they provided a cover story to the emergency department to cover up their misdeeds. Well, we know from her injuries what really happened. Tremendous force to her face, applied by 2 gentlemen hired to do just the same. And that's what they did. So over the course of her treatment at the hospital, she's in and out of consciousness. She's been administered ketamine by the paramedics. You'll see from the medical records when she gets there, she's administered morphine sulfate and oxycodone in 2 different forms while at the hospital. And you may ask, well, Miss Griffin's recollection of these events was kind of fuzzy. Well, when we take the entirety of the events in question and start analyzing them in their component parts, it becomes entirely reasonable why that is so. She suffers a blow at the hands of the bouncers, and she knew what had happened with pretty good clarity up until that time. But after that blow, she suffers a concussion. Her mental status is impaired. Thereafter, she's administered ketamine by the rescue personnel. She's taken to the emergency department, where she's admitted overnight and throughout the next day, and indeed through the next night. And over that course of treatment, while they're giving her the myriad of CT scans and x-rays and the things that they need to do to render appropriate treatment, she's given morphine sulfate and oxycodone to treat the pain. And we saw from the previous entry from the records, she comes in with a pain scale of 8, which is very high on the scale of 0 to 10, up near the maximum threshold. And then over the course of that treatment, we see the various CT scans. And bear with me one moment. And looking at the medical record of the CT scan of Miss Griffin of the facial bones with coronal and sagittal views, which are at Exhibit 3, page 84, we see that she suffers a right medial orbital wall and orbital floor partially displaced fracture deformities. She also is confirmed of that with the CT scan of her eye. And you'll see on page 26 of Exhibit 3, the injuries to her eye was significant. I will do my best so that you can view this as I proceed, but you'll have the ability to review these and blow these up back in the jury room for your own viewing. But you can see when she was in the hospital, they note the right medial orbital wall and orbital floor partially displaced fracture deformities, but they also note how she's doing in the hospital. She is still sleepy, not fully aroused from the ketamine. The emergency department attempted to pry open her right eye and was unsuccessful. They discussed it with a trauma surgeon who will admit for observation. Her eye was so swollen that they attempted to pry it open and could not do it. You will also see from the medical records, and this can be found at Exhibit 3, page 25, that when she's admitted, they run her toxicology screen on Miss Griffin. And you might think that, oh, well, she was just intoxicated and got coming to her what she had deserved. I would submit that the medical evidence paints a different story. When you look at page 25 of the medical records, you see what they've run as a toxicology screen. And under all drugs of abuse, and indeed even drugs that are prescribed, negative for all. All we have is alcohol in her system with a quantitative result of 66 milligrams per deciliters. As I said, when you do the math, this comes back to 0.066 or 0.07, under the legal limit. When they review the further scans of the brain, once again noted as the right medial orbital wall fracture with associated right intraorbital gas. We know that she suffered the orbital floor fracture from the CT scan of her maxillofacial area. Fortunately for her, there were no fractures to her back. And how did she appear as a result of all of this? Well, you have for yourselves the photographs of Miss Griffin that were taken that night. It's Plaintiff's Exhibit 2. The injuries are horrifying. You see there, she still has blood running from the top of her head and her nose. You can see from this image, not the best of the eye, we'll get that in a second, but clearly damage to the eye that they could not even pry open. Her lips are swollen with a gash to her lip that remains to this day, albeit healed, but still remains to this day. And then you see the picture of her trying to hold her face up so that her father can document these injuries. You can see just within hours, a few hours of the event, her eye is already bruised, swollen shut, to the point that emergency personnel or the emergency department of the hospital could not even pry the eye open. You see the cut to her lip. And then, to add insult to injury, we have her teeth. The 4 front teeth cracked out. Not entire teeth lost, just cracked teeth. And there it is. Within 2 days after the incident, there she is in the dental office. You can see her eye completely swollen shut, the damage to her lip. And there she is undergoing the dental treatment. And I want to talk for a second about what's reported at the dentist's office. And when you look at Exhibit 5, the ASAP dental records, there's an unusual entry. And I think it's best that we address it now. You'll note that when she first presents, she's just left the hospital after having the treatment and being prescribed the morphine sulfate and the oxycodone. And the statements made when she's in the complete state of pain, indeed, they note the patient could not tolerate further treatment, and they're just putting a temporary bridge, if you will, across her teeth, a temporary fix, that I was beaten up last night by my boyfriend and now my front teeth are cracked. Well, that's not exactly what happened, and let me share that for you so that you can see. As I said, this is in the ASAP records, and these can be located in those records, Exhibit 5 at page 2. I was beaten up last night by my boyfriend and my front teeth are cracked. All the while, she could not tolerate further treatment due to the pain. Well, we know that's not what happened because you've heard from Miss Griffin, you heard from Mr. Griffin, and he wasn't aware of any domestic abuse that had preceded it. He knew that the bouncers at the club did it. And I suppose that this was either the dental assistant either misheard Miss Griffin, or she was in such a state from the previously administered medication, that she was just out of it and perhaps went along with questions of the dental assistant about what happened. But nevertheless, we know what really happened. Her 4 front teeth got cracked, and they were cracked by the employees of defendant, for which they have already been determined liable. So the real question that we're dealing with is damages. What should Ms. Griffin be compensated for the injury she suffered in this case? Well, she had the original temporary fix and they couldn't proceed any further due to pain. She comes back in 2 days later for temporary crowns that they put on. And then over a month later, she comes in for the permanent crowns that were put on. And luckily and thankfully, I had her lean into the camera and you got to see the work, and they did a fine job. And I have to compliment them on the rush job that they did treating her on a Sunday. But she has 4 now crowns or false teeth in her 4 front teeth that you heard from Miss Griffin give her some level of self-consciousness and unease about her presentation. But we also know from the ASAP dental records that she incurred expenses from them. Here we have on page 5 of said records the breakdown of the costs associated with the treatment. And as I said, when you're back in the deliberation room, it's the payment column that totals up the amount of charges from ASAP Dental for Ms. Griffin's teeth repair. And as I said previously, that amount will total $4,749. In addition to that, there's a treatment plan that requires her to come back and have these re-imaged. Because those of you that have had crowns will know that they don't always last forever, and sometimes they need to be repaired and they have to be monitored on a periodic basis to make sure that everything is taking well. And that's what they've recommended here with the 5th visit that Ms. Griffin is yet to obtain. There's a cost associated with that of $227 that she's going to need to go back in and have that additional work performed. In addition to the records from ASAP, we know what the medical bills from Memorial were for her treatment there. We know from page 6 of Exhibit 6 that the total cost of her medical care during her stay at Memorial was $39,864. And that was for the visit to Memorial for the brief 48 hours she was there. Now, Ms. Griffin has testified that the doctors encouraged her to go back and explore whether she should proceed with getting reconstructive surgery. As you can see from the screen, Ms. Griffin's been with us this entire trial. She's a beautiful lady, and she doesn't feel she needs that reconstructive surgery. So we're not asking for you jurors to come up with a medical damages award for future medical reconstruction, because she's elected not to get it. There's an old adage, if it ain't broke, don't fix it. Well, it was broke, but fortunately for her, it's healed, and she's still a beautiful young lady, but we're not seeking any future medical expenses for any damages associated with her fractured orbital or any possible reconstructive surgery. She's elected to proceed in her life without it. The only other out-of-pocket medical that we've discussed here is the billing records of Dr. Beck, and his records can be found at Exhibit 4, specifically page 2 of Exhibit 4. There is an outstanding medical bill of $200 from Dr. Beck. And so when you total up all of Ms. Griffin's damages in terms of her out-of-pocket prior medical expenses, it produces a total of $44,833. In addition to that, you have future medical expenses. We have the $227 of ASAP dental care, but she's also testified about her need for further psychological treatment. We know from her testimony, as well as the medical records, that she had previously suffered from conditions of anxiety and ADHD. And you may have seen some features of those conditions during her testimony today. You could possibly see her shaking on the screen, very difficult time providing testimony about the events itself, and more troubling to her, the way it makes her feel this 2 years plus removed from the event, having to relive those moments and recount what it does to her psychologically today, doing the deep digging that one has to do to provide insight into one's life, to try to overcome trauma such as this, to become a better person going forward, to become whole again if you ever can. And she believes that she will continue to need that counseling up until discovering that she was pregnant with child and that she would not be receiving the medication that she had been taking. She ceased taking that and has continued to cease taking it up until the birth of her child, who's now 7 months, but it believes that she is going to require further medical treatment, psychological counseling with a psychiatrist. And her testimony upon a juror question in terms of how much that cost going into the future was $200 to $250 a session. So let's take the conservative estimate of $200 a session for monthly counseling. And who knows how long it would take for her to heal the psychological wounds that arose from this event. But let's say another year of counseling at the tune of $200 per session per psychiatrist. And if you do the math, 12 months times $200, that figure produces a sum of $2,400, $2,400. So when you add that to the $227 from the ASAP dental, you're now talking $2,627 in future medical care. And the judges instructed you with respect to future medical that should be reduced to a present money value, the amount of money that it would take today, plus what that would accrue in the future to pay for that treatment as it's incurred in the future. And roughly, I think a good approximation of the present money value of that sum, but that's for you to deliberate and decide amongst yourselves. But I would submit that a sum of $2,000 would be appropriate for the future medical. So what are the other components of damages that Ms. Griffin seeks? Pain and suffering. Undoubtedly, the pain and suffering experienced by Ms. Griffin as a result of this was tremendous. She's reported on her emergency department entry as a pain scale of 8. And that's because of the fractured orbital floor, the fractured orbital wall, the cracked teeth, and all of the trauma to her face associated therewith. Her eyes swollen to the point that they could not pry it open. And that persisted for months, according to Mr. Griffin. He helped raise his daughter, and you could tell what the emotion that it caused with him. And you know the emotion that it caused with Miss Griffin having to relive this. But the pain persisted from February all the way through to the summer. She couldn't work, she was in pain, and went into a hole, as her father said, was not the same bright young lady that he had raised and grew up and knew as a young daughter in his life. She was a changed woman. She was in tremendous pain, worried about her appearance. She was a woman that had pride in her appearance prior to this, and thankfully she started to restore herself to her former self and take pride in that. She was unable to work for nearly 18 months and then briefly went back to work as a dancer. And why? To pay her college tuition, and then ceased doing that and turned her life around. She enrolled full-time in college, where she's getting a degree in business administration. Works full-time for Florida Blue as a customer service rep, and on top of it all is raising a beautiful 7-month-old daughter. But these injuries, not only the physical, but they've left psychological scars upon her as well. Every time someone sees her and makes note of her appearance, whether it's the scar or the appearance of her eye, she has to relive the events. and she has a very difficult time doing so. It takes her right back to that dark place in the early morning hours of February 17, 2018, and the questions that arose. Why did this happen to me? What did I do to deserve this? Why me? And has to consciously battle those feelings every time that the matter comes up. She's worked through it for counseling, saw a counselor and psychiatrist every month for a year following the incident, and is going to need that in the future. So the damages suffered by Ms. Griffin, both in the form of pain and suffering, and taking the months for her facial fractures to heal with her cracked teeth and the months-long dental work that took, tremendous amount of pain and suffering in this case. And you know from the photos. The pain she experiences is palpable because you can see it for your own eyes. You see the swelling. You see the fracture. You see the cracked teeth. You see the writhing in pain. You see it in living color. And then you see her in a more sedated state, eye totally swollen shut, months to heal, a year and a half before she's able to return to work. So the pain is palpable and it's great. The mental anguish and emotional distress, palpable and continues to this day. And it will continue with her, I submit, for the rest of her life. Now, she's had some positive events to help bring her forward. As I said, she's turned her life around and she's now working full-time, in school full-time, and on top of that, raising a beautiful young baby. But we're here asking a jury to return a fair and just verdict in favor of Ms. Griffin. So let's take a look at the verdict form in this case, because that's the jury's task. As the court read in jury instructions, the task for the jury in this case, where liability has already been established, is to prove or award Ms. Griffin damages for her injuries. Indeed, the court read to you, she is to be awarded damages for any bodily injury sustained and any resulting pain and suffering, disfigurement, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damages. The amount should be fair and just in light of the evidence. In addition to those damages, the jury is to award the reasonable expense of hospitalization and medical care, and in this case, dental care, and treatment necessarily or reasonably obtained by Ms. Griffin in the past or to be so obtained in the future. So, when members of the jury, you get back into the jury room and you're tasked with determining the amount of damages to which Ms. Griffin is entitled, you'll be reviewing this form, the verdict form, and blowing this up in an effort so that we can all read it. And the first question that you will be asked is, what is the total amount of medical damages, including all medical bills sustained by the plaintiff, Cayla Griffin, caused by the incident in question? Well, these, what we had discussed in jury selection, voir dire, is what are referred to as the economic damages, or the hard damages, those damages that produce receipts and bills. And so we know from the record evidence, which you'll have an opportunity to review, the total amount of medical damages and medical bills, dental bills sustained in the past. We have $39,884 from Memorial Hospital. We have 200 from Dr. Beck. And we have another 4,749 from ASAP Dental. And you'll have to forgive my rudimentary art skills on this, ladies and gentlemen. I feel like it's a kindergartner doing some elementary math, trying to do this with a computer stylist, so if it does not come out very eloquent, please don't hold it against me, and certainly don't hold it against Ms. Griffin. But the total, when you total up those amounts, when you look at all the billing records in this case, it produces a figure of $44,000 $833. When we talk about future medical, the amount, we're not seeking much because fortunately for Ms. Griffin, she's healed to a large extent and won't require that very expensive reconstructive surgery. But she will require some follow-up dental care and will require some additional counseling. And we submit that a reasonable future estimate of that counseling would be an additional year at $200 per session. And when you add up the $227 and the $2,400 in future counseling expenses, it produces a sum, excuse me, let me try to start over. As I said, my skills in this regard are a bit rudimentary. It produces a sum of $2,000, $2,627. And that brings us to the total amount of damages suffered by Ms. Griffin for the pain and suffering, both in the past and in the future. And as the jury instruction reads, there is no exact standard for measuring such damage. The amount should be fair and just in light of the evidence. Well, there is no medical bills. There is no receipts. It is what is fair and just in light of the evidence. Well, you've seen the pictures of Miss Griffin. Bear with me. In Plaintiff's Exhibit 2, you have the images of the pain and suffering. What is it worth? It's a very good question, and it's the most difficult task that this jury is going to have to perform in its deliberations. But we know it took several months for her to heal. We knew it took over a year for her to be in a position to return to work. We know she went to counseling for a year, on a monthly basis for a year. We know what the medical evidence documents about the nature of the injury that produces this pain and suffering. We know about the medical evidence that produced the scarring and disfigurement, which produced all of the mental anguish and emotional distress. And I would submit to you, for the level of damage, the crushed face, the fractured teeth, and all that went with, and the feelings of low self-esteem that it produced or in heightened, that a reasonable sum in the amount of past and future pain and suffering would be $250,000. And we respectfully request that you members of the jury compensate Ms. Griffin for the pain and suffering experienced as a result of these 300 and 250 pound men crashing their fists into her face and dropping her to the pavement to suffer these horrifying injuries for which they could not pry her eye open, and it shattered her orbital in multiple places, as well as her teeth that needed months of reconstruction to be able to put back together so that she could be out in public without the concern of people staring at her in this grotesque in this grotesque fashion. So we would respectfully submit that when you go to that verdict form once again, that you put for pain and suffering damages for $250,000. I would submit 200 would be appropriate for past pain and suffering. And an additional 50 for the future pain and suffering, mental anguish, and emotional distress. And that, ladies and gentlemen, is what I submit would be a fair and just verdict in favor of Ms. Griffin. However, it is your job to determine what the evidence supports and what would be fair and just to Ms. Griffin. Once again, I want to thank you for your time and attention. I want to thank you for suffering through many of the technical difficulties that we've had in this case, not through any fault of the court, maybe some fault to me, but please forgive me. Technology is not my forte. It's just the nature of the beast. We're doing this for the first time in this circuit and perhaps the first time nationally. And I want to thank you for devoting your time and attention and your efforts in this case. I know Ms. Griffin thanks you for your time and attention to this case. And I wish you the best in returning to that jury room and returning a fair and just verdict in favor of Ms. Griffin.
Thank you, Mr. Kurtis. All right, I'll now transition over to my final closing instructions. So Mr. Ashley, if you could pull up the page that we left off on, entitled Closing Instructions, and share screen for the jury. Ladies and gentlemen of the jury, you can unmute your microphones. Can all of you see the page that we're on now, section 700, closing instructions? I need an audible yes or no.
Yes.
Yes.
All right, very good. If there's anyone that can't see it, please let me know at the present time. All right, it appears that all of our jurors can see those closing instructions on the screen that I'm about to read. Please listen closely. Again, these are from the Florida Supreme Court. I have made some minor modifications to accommodate the fact that we're doing the very first remote civil jury trial. So there are some slight differences, but again, I don't have these instructions memorized, so we'll have to read them to you as they scroll on the screen. So listen closely. And you'll have these instructions in the jury room as well when you deliberate, so please don't attempt to take notes. You will have them available to review. Members of the jury, you've now heard all the evidence, my instructions on the law that you must apply in reaching your verdict, and the closing argument of the attorney. You will shortly retire to the remote jury room to decide this case. Before you do so, I have a few last instructions for you. During deliberations, jurors must communicate about the case only with one another and only when all remote jurors are present in the remote jury room. You will have in the remote jury room all the evidence that was received during the trial and a copy of these instructions. In reaching your decision, you do not do any research on your own or as a group. Do not use dictionaries, the internet, or any other reference materials. Do not investigate this case or conduct any experiments. Do not visit or view the scene of any event involved in this case or look at any maps or pictures on the internet. If you happen to pass by the scene, do not stop or investigate. All jurors must see or hear the same evidence at the same time. Do not read, listen to, or watch any music counts of this trial. You're going to have this evidence in the exhibit in the Dropbox. It's going to be sent to your remote jury room. And when you all review the evidence, you must do so at the same time. In other words, all of you should be sharing the same screen, reviewing the same evidence. No one should be going off on their own and doing their own investigation, even of the evidence that was admitted into evidence in this case during the course of the trial. Everyone should review it together. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you, whether they be in your home or in your office or wherever you're participating in this from or anywhere else using electronic device, such as a family accountant, a doctor, or a lawyer. These communication rules apply until I discharge you at the end of the case. I also need to advise you that I know all of you have your own cell phones, tablets, laptops, or other electronic devices, and to be very clear, just so there's no miscommunication, just as I've been telling you all throughout the trial ever since I first met you last week, except for whatever electronic device you're using to serve as a remote juror in this case, The rules do not allow you to bring any such electronic devices not being used by you to serve as a remote juror into the remote jury room. So that means the same rules apply. All those devices, your watches that can transmit data, anything at all that could be used other than the device you're using to participate here today should be turned off, out of sight, out of mind. So please kindly leave those devices in another room powered off so as not to be a distraction to you while you deliberate. Also, as for whatever, again, the same rules apply as I've told you before, as for whatever electronic device you're using to serve as a remote juror during these deliberations, please turn off or log out of any websites, social media, messaging services, email providers, direct messaging, instant messaging, any documents you have on the screen that you might have been working on during recesses, anything at all that could possibly pop up on your screen and distract you from giving your undivided attention to your remote juror deliberations to reach a verdict. Please close out of all that stuff and get out of it, because until you're discharged as a juror during these entire deliberations, we need your undivided attention on this case and on the evidence and my instructions and your deliberations. So please abide by that. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by sending a message to Magistrate Hodak or to the remote juror bailiff. Please send a direct message to them using the chat feature in Zoom. Any notes you have taken during the trial may be taken to the remote jury room for use during your deliberations. Your notes are simply an aid to your own memory, and neither your notes nor those of any other juror are binding or conclusive. Your notes are not a substitute for your own memory or that of any other jurors. Instead, your verdict must result from the collective memory and judgment of all jurors based on the evidence and testimony presented during this trial. At the conclusion of this remote trial, I'm ordering you to immediately destroy all of your notes to ensure that no one will ever read your notes after this case is concluded. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision. Your verdict must be based solely on the evidence that has been received and the law in which I've instructed you. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way, and you should not guess what I think your verdict should be from something I may have said or done during the course of the proceedings today or during jury selection last week. You should not think that I prefer one verdict over another. Therefore, in reaching your verdict, you should not consider anything that I may have said or done except for my specific instructions to you. Please pay careful attention to all the instructions that I gave you, for that is a law that you must follow. You will have a copy of my instructions with you when you go to the remote jury room to deliberate. All the instructions are important, and you must consider all of them together. There are no other laws that apply to this case. And even if you do not agree with these laws, you must use them in reaching your decision in this case. When you go to the remote jury room, you'll be given instructions on the technology features to use to view the evidence and to fill out the verdict form by the remote jury bailiff. You will also be given instructions on how to fill out the juror inquiry form in the event that you have a request to the court or a question to ask the court while you're deliberating. All of that you'll be given when you go back to the jury room. After the remote jury bailiff leaves the jury room, the first thing you should do is choose a presiding juror to act as a foreperson during your deliberations. The foreperson should see to it that your discussions are orderly and that everyone has a fair chance to be heard. So after you go back to that jury room, pick your foreperson, you're going to hit the help button in the Zoom platform that you're going to learn about when you go back there. And that will be a signal to the remote jury bailiff to go back to the jury room to find out and confirm that you have picked a foreperson and the identity of that foreperson. It is your duty to talk with one another in the jury room and to consider the views of all the jurors. Each of you must decide this case for yourself, but only after you have considered the evidence with the other members of the jury. Feel free to change your mind if you're convinced that your position should be different. You should all try to agree, but do not give up your honest beliefs just because the others think differently. Keep an open mind so that you and your fellow jurors can easily share ideas about the case. I will give you a verdict form with questions you must answer. You will access it through the court technology system. I have already instructed you on the law that you are to use in answering these questions. You must follow my instructions in the form carefully. You must consider each question separately. Please answer the questions in the order they appear. After you answer a question, the form tells you what to do next. I will now review and read the verdict form to you. You can go ahead and scroll to the next page, Mr. Ashley. That verdict form is now on the screen in front of you, and you will have this verdict form in the jury room to review in the jury room itself, but more importantly, you'll have an electronic version of this verdict form to fill out when you've reached a verdict. So the verdict form is on the screen. I'm holding it in my hand right here. It says at the top, verdict. We, the jury, return the following verdict. Number one, what is the total amount of medical damages, including all medical bills sustained by the plaintiff, Cayla Griffin, caused by the incident in question? And below that, it has subparagraph A to the question. In the past, and to the right of that, you'll see a $ with a line, and that is for you to fill in the amount of the past medical damages, and that amount has to be the verdict of each juror and the jury as a whole. Below that, you'll see the letter B that says in the future for you to fill in the amount of future medical damages. Whatever amount is entered on that line to the right of the word future, with the $, the line provided for you has to be the amount of the future medical damages that each juror and the jury as a whole agrees to. Then it says, please answer question 2. Question 2 says, what is the total amount of any damages suffered by plaintiff Cayla Griffin for pain and suffering, physical injuries, mental anguish, and emotional distress caused by the incident in question? And below that it says, has subparagraph A to the question, in the past. And then to the right of that, the word past, you'll see a $ and a line provided there to fill in the amount. That amount that you fill in for past damages for pain and suffering, physical injuries, mental anguish, and emotional distress has to be unanimous. That amount has to be the verdict of each juror and the jury as a whole. Then below that, you'll see a letter B as in Bravo, the subparagraph B to the question, in the future. To the right of the word future, you'll see a $ with a line to the right of the $. And then that line is provided for you to fill in the total amount of the future damages suffered by the plaintiff for pain and suffering, physical injuries, mental anguish, and emotional distress. Whatever amount is filled in there by the foreperson has to be the amount that each juror agrees on and the jury as a whole, and that has to be a unanimous verdict. The foreperson is going to be filling out this verdict form, but it has to be a unanimous verdict of all the members of the jury. Below that it says, so say we all, this blank day of August 2020, the foreperson will enter the date. The foreperson will electronically sign his or her name as a foreperson by using the S / and then the name printed in there. And then once that's completed, you'll hit the help button, and then the verdict form will be submitted electronically, and you'll learn how to do all this to our remote bailiff, who will then tender it to the court for review, and you'll come back to the courtroom. You can go back to the previous page, Mr. Ashley. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. When you have agreed on your verdict, your foreperson must write the date and sign it at the bottom. And when the verdict form is completed, notify the remote jury bailiff. If any of you need to communicate with me for any reason, please send a message to Special Magistrate Hodak or to the remote jury bailiff, James Muse, and you'll see there's a chat message for sending a message if there's something that's come up that is outside of an inquiry or a question or request. But the formal way that I require you to send a formal request or question to the court is through that form that you'll learn about when you go back to the jury room. Otherwise, if it's an emergency or something's come up that's outside the realm of the juror inquiry form that you're going to learn about, that can be done with a chat message to either Special Magistrate Hodak or to our remote jury bailiff, Mr. Muse. The remote juror inquiry form that you're going to learn about back there. When you send that note to me in the form of the remote juror inquiry form, that form should not disclose any vote or split that you have within the jury as to the verdict. That form should be used to communicate to me whatever. You'll see that form. It has all the lines for you to fill in as to what your request is or what your question is. So at this time, you will be retiring momentarily to decide your verdict, but first I have to excuse and discharge our alternate jurors. So before you go back to the remote jury room, Mr. Ashley, you can pull down those instructions. So before I go any further, Mr. Kaczurgas, as to those remaining instructions I've given to the jury, are there any exceptions or objections?
No exceptions or objections, Your Honor.
All right, so for the record, I have signed these jury instructions and dated them today's date. I will tender these to our trial clerk at a later time to be filed and made part of the court file as the instructions I've read to the jury. As I said earlier, I can't dismiss you or send you all to the remote jury room to begin the process of, number one, doing the part 3 presentation about Zoom skills needed for deliberations and picking a 4-person until I discharge and dismiss the alternate jurors in this case. And we do have 2 alternate jurors in this case. And for the record, they are, the first alternate was juror number 7, Mr. James, and the second alternate was juror number 8, Ms. Joyner Rogers. And so for you all, only 6 jurors are allowed to deliberate a case like this. And Mr. James and Ms. Joyner Rogers, you have our collective gratitude and thanks. The court, Mr. Kaczurgas, Ms. Griffin, all of our participants in this trial, we all thank you for your time and attention in this case. And we do appreciate all the time that you spent in this case. And I do want to let you know that alternate jurors are just as important as the 6 jurors are going to be deliberating this case. And the reason I can say that is because I can briefly tell you that before I became a judge, one of my stories I can tell you when I was a trial attorney myself is that in the middle of a 3-week complex civil jury trial, we had 8 jurors, just like in this case, and we lost 3 jurors. We lost one to a car accident who was injured and went to the hospital. We lost a second one who got sick in the jury box during my direct examination of a witness. I guess it was something I said or did, but that juror got sick in the jury box, had the flu, and had to leave. My trial partner and I thought we were home free. We still had 6 jurors. And unfortunately, the 3rd juror that had to be excused was exposed to tuberculosis at UF Shands, had to be dismissed. The rest of the case was a mistrial. We all had to go get tested for tuberculosis, and there was a mistrial. We had to start the case all over again about a year later. So with that being said, I tell you that story because Ms. Joyner Rogers and Mr. James, your presence here allowed us to complete this case and get it to this point where we can hand it off to the remaining jurors to deliberate. If any of your fellow jurors have become ill or unable to serve, one of you or both of you would have had to step in for those jurors. So we thank you collectively for your service in this case. So at this time, you have several options as alternate jurors. The first option would be you could just simply click the option on your Zoom screen for leaving the room. That means you're leaving the remote courtroom with our collective thanks, and you'll move on and go about your business with my only instruction to you that you not discuss this case or anything about this case with anyone until you know that a verdict has been entered. The second option is that you could simply turn off your video and turn off your audio, and you could join the remote gallery of spectators who are now watching the trial. There's a number of them there, including the media. You could remain there with them, and you could watch the remainder of the trial to see what the outcome is, knowing that you cannot go into the remote jury room, but at least you can watch and wait for the verdict at a later time. Or you can, if you indicate that you want to know what the verdict is, you can still leave. You can still leave the room, leave the remote courtroom, and one of our remote bailiffs will contact you after there's a verdict to let you know the outcome. So I'll start in order. Mr. James, would you like to stay with us and turn off your audio and video and just remain with the spectators knowing you can't discuss the case with them? Or would you like to leave?
I'd like to leave and know when the verdict is concluded.
All right, so we'll make a note then. I think we have your contact information, and one of our remote bailiffs will let you know after the verdict what the outcome was. All right, so
Yes,
you may leave the room at this time, Mr. James, with our collective thanks. You can leave the remote courtroom. Thank you so much for your service, and thank you for allowing freedom to ring. Now, Ms. Hodak, Ms. Hodak had a reminder. I think I know what it's going to be. Mr. James, there's one final instruction I need to give you other than not talking about the case so you know there's a verdict. You're going to get an email. That email is going to thank you for your service, but it's also going to include a survey that you need to fill out in order to give us information we're going to need to help us with this pilot program going forward. So I'm going to ask you, I'm ordering you that when you get that email to open up that link and answer that survey, okay?
Yes, sir.
All right, any other instructions for Mr. James that left off, either Special Magistrate Hodak or Mr. Muse? Anything else you need to address with Mr. James?
no, Your Honor.
All right.
No, sir.
All right, thank you. So, Mr. James, you can now leave the remote courtroom with our collective thanks.
Thank you.
All right, that takes us to juror number 8. Ms. Joyner Rogers, have you decided whether you want to remain in the gallery and watch the outcome of the trial or leave the remote courtroom?
Once you leave, you can't come back, right?
Ma'am?
Once you leave, you can't come back.
Well, I think you can come back, but you just have to come back with the audio and video off. I don't know how long the length of time we're going to be here today depends on how long the jury deliberates. That's going to be up to them. So if we're still going, you could obviously use the same address and join us, but I would ask that you do so with the audio and video turned off. Is that fair, Mr. Smith?
Yeah.
Well, let me ask Mr. Smith if that's possible. Is that possible, Mr. Smith?
Yes, sir. She can rejoin. Miss Joyner Rogers can rejoin if she leaves this meeting right now, and we'll be sure to let her back in. We just don't know the time, of course.
Right. So we don't know how long we'll be here, but you're welcome to rejoin us. If in the event that you don't rejoin us and don't know the outcome, do you want one of the bailiffs to let you know what the verdict was?
Yes.
Right. So the same instruction you, Miss Joyner Rogers, you're going to get an email regardless. That email is going to thank you for your service, but it's also going to contain a link to fill out a survey with useful information that we're going to need to know about your experience as a remote juror to help us moving forward. So I'm ordering you to please fill out that survey when you receive the email, okay?
Okay.
All right, so Ms. Joyner Rogers, thank you so much for spending all this time with us last week and this week. And thanks to you, freedom is ringing here in the Duval County Courthouse. The sound of freedom has been heard once again, and we thank you so much for your service. And you are free to leave the remote courtroom at this time, and also free to return if we're still going later on.
Okay, thank you.
All right, thank you. All right, let the record reflect that our 2 alternate jurors have left the remote courtroom. And so at this time, I am going to send our remote jurors, our 6 remaining remote jurors, into the remote jury room, and at which time you'll get an invitation to go back to the remote jury room. And at that time, you will be shown the PowerPoint tutorial part 3 about Zoom skills you need for deliberations. And then also you'll be left in there to pick a 4-person. And so what I'm going to do at this time, I suspect, Mr. Smith, you know about how long that presentation takes to present to the jurors? Is it 5 minutes, 10 minutes? What do you think?
Your Honor, it would be between 5 and 10 minutes. I would give it 10 minutes just to make sure if there's any questions, we have time to answer the questions.
Okay, so ladies and gentlemen of the jury, we're not going to be in here in the remote courtroom having small talk and talking about news, weather, and sports while you're in there doing the PowerPoint presentation on Zoom skills for deliberations and picking a 4-person. We'll be in here reviewing the evidence to make sure that what's going to be Dropbox to you is what should go back to you. So we'll be working hard in here while you're working in the remote jury room. So at this time, I want you to accept the invite to go to the remote jury room, and myself and Mr. Kachurgis and our deputy trial clerks, Mr. Rogerson and Ms. Irizarry, and our court reporter will remain in the courtroom to review the evidence that's going to be sent back via Dropbox. So at this time, you're now excused to go back to the remote jury room. All right, let the record reflect that all 6 of our jurors are in the remote jury room. Mr. Muse, are you going to be with them, or is Mr. Estelila doing the PowerPoint presentation?
Mr. Estelila is going to set up and do the PowerPoint presentation. I'm here so I can set up the alternate remote clerk room for Mike and the clerk to review the exhibits.
All right, so at this time, present in the courtroom, we're still on the record. We still have the court reporter with us, I believe, and we have, yes, I see her image on the screen. Court reporter is with us, as well as our special magistrate, Ms. Hodak. Mr. Rogerson, our trial clerk, is with us. And we have Mr. Muse, our remote jury bailiff, and Mr. Smith, our remote trial bailiff. We have the plaintiff present along with Mr. Kuchurgis. What we want to do now is review and make sure that all the exhibits are going to go in the Dropbox, or what should go in there. The exhibits marked 1 through 6, number 2 being a composite exhibit, and the jury instructions that are in there are the ones that should go back to the jury. So at this time, I'll give you an opportunity to confer, Mr. Kuchurgis, with the trial clerk and Mr. Smith to make sure that's what is going back there is what should go back there.
And you want to
Mike,
do
I might need a copy of the link to the Dropbox. I'm not sure I still have that.
Okay, can you all send that by message to Mr. Kuchurgis?
It's coming to you now, Mr. Kuchurgis.
And can you send one to the court as well, Mr. Muse?
Yes, sir.
And me as well, please.
All right, Mr. Rogerson as well.
All right, the court, Mr. Kuchurgis and Mr. Rogerson should have that link now, Your Honor.
All right.
It's in the chat, right?
Correct. Yes, sir.
Very good. Thank you.
I just received mine.
Was everybody able to open that link and retrieve the exhibits from Dropbox successfully?
For the record, the court has received the Dropbox and is able to open them.
Perfect. Thank you, Your Honor.
Your Honor, this is Patrick.
Yes, sir, Mr. Estelila.
I just went and told the jurors to go ahead and pick their 4 personnel so that whenever they have informed us that they do have picked the 4 person, then I can go ahead and give them that PowerPoint instructions for the other 2 forms.
I know you're still gonna have to come back out and let us know who the 4 person is.
Yes, sir. Yes, sir. Yes, sir. But I'm letting them pick the 4 personnel, so whenever they've decided that, at least I can talk to the 4 person about the process of filling out the verdict form and the inquiry form.
All right, well, okay, well, that sounds good to the court. I think that's a good plan from a logistical standpoint. All right, I'll let Mr. Kuchurgis and Mr. Rogerson, I'll let you all look at the exhibits and advise the court.
Your Honor, would you like me to share those exhibits for everyone to see on screen to go over them, or are you going to do them individually?
I'm going to let everyone look at them individually because Mr. Rogerson may be looking for different things that I'm looking for, and Mr. Kuchurgis may be looking for different things as well. So I'm going to let everyone look at the exhibits individually for now.
Okay, yes, sir. And Your Honor, we just got notification from the jurors that they are asking for help, so I'm going to join them in the remote jury room. Mr. Estelila, if you want to join me as well.
All right, very good.
Sounds good.
Ms. Hodak, did you want to see the Dropbox as well?
You're muted.
You're so muted, Ms. Hodak. Sorry. Ms. Hodak, did you want to take a look at it?
If you would like me to, Your Honor, but
It's up to you. I didn't know if you want to take a look and see what it looks like just for,
Sure.
for the sake of the program. So Mr. Smith, can you forward that Dropbox to Ms. Hodak as well to look at?
She should have it in her chat.
Okay,
I received it and can open. Thank you.
very good.
And Your Honor, they were able to pick a 4-person. Would you like me to announce that information to you now?
For the record, I'd like to know who they selected as a 4-person.
Okay, Your Honor, they selected juror number 3. That would be Charles Tech Wells.
All right.
And Bailiff Estelila is currently giving them their instructions as well as showing them the PowerPoint for Zoom skills and the verdict and inquiry form instructions as well.
Okay, all right. Sounds good. All right, so for the record, we have juror number 3, Mr. Wells, as our 4-person.
And I'm also going to join Mr. Estelila in the remote jury room to go over those instructions.
All right, will you just come after they're completed, you let us know, and hopefully we'll kind of finish the review of the exhibits around the same time.
Yes, sir.
Your Honor, I completed the review of the evidence and it matches what I have as the hard copies.
All right, very good. Mr. Kachergis, do you concur?
I do. I just completed my review and it looks in good order to me.
And Mr. Kachergis, do you agree that the instructions that are going back in the Dropbox are the same instructions I just read to them?
Yes, sir.
All right, very good. Any other housekeeping matters we need to address while Mr. Estelila is and Mr. Muse are doing the Part 3 Zoom tutorial for skills needed for deliberations?
I just have a question. In the jury instructions, there's also the IT instructions. The initial, it looks like PowerPoint 1 and PowerPoint 2.
Yes. Those have been up there from the start. We didn't put the third one up. They're putting it up now because it had the verdict instructions on it.
I think the plan was that they left them in there so if they had issues, they could just, look at them again without having to have them go in and explain it.
Understand. Thank you.
Ms. Kachergis, do you have any objection to those tutorial slides still being in there, Part 1 and Part 2?
No, they may actually be helpful to them.
Okay. And then obviously Part 3 would be made a part of it after the presentation is done. Any objection to Part 3 that you've already reviewed going in there as well?
No, Your Honor.
Okay. What I'd like to do, Mr. Smith, while we're at it, is I'd like for you to print out Part 1 and Part 2 and Part 3, make hard copies of those. I'm going to have those marked as courts exhibits for identification, just so we have a record of it. I think it would be helpful going forward. So for the record, what's going to happen, Mr. Smith, is I'm going to need you to print out Part 1 of the PowerPoint Zoom tutorial. Will be courts exhibit P as in Paul for identification. And once you get it, once I receive it, once I print it out, I'll so mark it. I think Mr. Smith, is it in a form I can print it as it's in the chat message?
Yes, sir. If you open it in that folder that's in the Dropbox right now, it's
Yeah.
PDF. You can print that as is.
Okay. And then what I'll do is Part 2 of the PowerPoint Zoom tutorial marked as courts. I'm sorry, with me, I'm on the wrong letter. So actually part 1 would not be exhibit P as in Paul, it'd be exhibit K as in keep. Where we left off on J this morning, so we'll be picking up with K. So let me strike what I just said earlier. The PowerPoint Zoom tutorial part 1 will be Courts Exhibit K for identification purposes. Part 2 of the PowerPoint Zoom tutorial will be Courts Exhibit L for identification. And then part 3 of the PowerPoint Zoom tutorial will be Courts Exhibit M as in Mark for identification. I'm going to go ahead and print those out. When you get part 3 done, you can send it to me in a chat message and I'll print it out, but I'm going to go ahead and mark those exhibits at the present time. They'll be tendered to the clerk at a later time for the record.
It should be in there any minute, Your Honor. I'll let you know when it's in there.
All right. Mr. Smith, the printing on this doesn't, it looks kind of strange. The print preview looks strange on it.
One second, Your Honor. You may need to download it first to your hard drive, Your Honor.
Okay.
I'm not sure if the print driver from that whatever browser you're using is compatible.
It may not be, that may be the problem, but I'm just saying that for the record. If we have to figure out later how to get it printed, we will. It's asking me to sign up for Dropbox. That may be why. I don't know.
Yeah, these are read-only, I believe, so that they couldn't be changed. So I'll make them available to you as soon as we're.
Okay. Yeah, it's not the biggest issue right now. We can print and save later. I'm making a note about it.
Your Honor, also, I'd like to let you know that as soon as we were notified that there was a foreperson, we enabled the inquiry form and the verdict form that were not, I'm going to say the word hidden up until then they were hidden, but they are available now for the jurors.
Okay, very good.
And that would be in Sophia, Mr. Smith?
That's correct, Ms. O'Day.
Thank you.
While we're waiting on our remote bailiffs to return to the courtroom so that we can send in the Dropbox, I will say, I'll make this comment. I'm saying this to everyone. This is those that are present here as well as those that may watch at a later time that have been volunteers on this project. I'm extremely proud of the effort that everyone has made to allow us in such a short time to be prepared to put on the first remote civil jury trial. Everyone shares the credit for us to get to this point that we're at today with the jury on the verge of being able to deliberate. I also want to give a special thanks not only to all of the AVOTA volunteers, Ms. Hodak and all her individual efforts, but also to our court technology officers. Without their incredibly hard work, Mr. Smith and Mr. Muse, Mr. Estelila, Mr. Ashley, all of the CTOs, there's no way we could have done this without their very hard labor and work. I mean, this is countless hours of nights and weekends and afternoons and Friday all day mock trials. And I want to thank everyone. I also want to thank the clerk's office, because everyone at the clerk's office, Mr. Corrigan, Mr. Rogerson, Ms. Irizarry. They've all had a part to play in this. And Mr. Fussell has been very open-minded to doing things differently and in a new way. And I certainly appreciate all the efforts by the clerk's office. And I also want to thank specifically Mr. Kachergis for stepping up and being the first lawyer to try a remote civil jury trial. It takes a lot of courage to try a case, but be the first one to do one in a new way, a new method takes a lot of courage. I want to thank Mr. Kachergis for stepping up on behalf of his client and trying the case remotely. And it makes me proud. I'm proud of everyone that's participated in this, but it makes me grateful and proud to be a judge in the Fourth Judicial Circuit because of the great court personnel that we have here, but also the great lawyers that we have in the Fourth Circuit who are willing to step up and volunteer and do the hard work to make things happen, to be innovative and collaborative. And so it's been a very proud, I've always been proud to be a judge in this circuit. I was proud to be a lawyer in this circuit, but at no point in my career as a lawyer or a judge have I been more proud. And I also want to thank the Chester Bedell Inn of Court who participated in the mock trials as well. I know there are so many volunteers, and every time Ms. Hodak asks for volunteers from Inns of Court and from the North Florida chapter of ABOTA, there was never a shortage of volunteers, and sometimes it was even children of lawyers who stepped up, teenagers, college students who stepped up to volunteer. We also had staff members from various law firms who stepped up. And so it's really been a collective team effort from June until now to get us to this point. So I just want to take this moment while we're waiting on the training to be completed to give all of those kudos to everyone involved. So I do see Mr. Estelila and Mr. Muse have returned to the courtroom. Have the jurors completed all of that training?
Yes, Your Honor. The instructions been given to both of the forms, and the exhibits links have been shared to them as well. So they're ready to.
We were able to confirm they were all able to open the link. They've all been, we did the share screen test with the 4-person. Everything should be smooth sailing. We reiterated many times, if they have any questions, please use that ask for help option as much as they need to.
Okay, so at this time, are there any other matters to take up before we send the exhibits and the instructions via Dropbox to the jurors?
No.
All right. So Mr. Muse and Mr. Estelila, those part 3, that part 3 PowerPoint Zoom tutorial for skills needed during deliberations, will those be available for them in the remote jury room as well as the ones that are already part of the Dropbox?
Yes, sir. They were just added. Part 3 was just added to the Dropbox about a minute and a half ago. So as soon as we grant them access to this Dropbox, they should have it.
Right. And for the record, while you were working in there, Mr. Kachergis and Mr. Rogerson have confirmed for the record that that all the contents of the Dropbox are the exhibits that should go back to the jurors, along with the copy of the instructions. I just read them and have approved of the tutorials for Zoom part 1, part 2, and part 3 to go back to the jury. So with that, I will order you to go ahead and send the Dropbox to the jurors in the remote jury room. And once you've given a moment for that to get back there, I want one of you to go into the remote jury room to confirm that they've received it and can open it before coming back out to let them start deliberations.
Okay. Yes, sir. Patrick, if you want to go in there, just go down to breakout rooms and I'll make sure they have the link.
Sounds good. I'm on the way.
Your Honor, if we're done with the housekeeping and other things, I think I could use.
You have one more housekeeping matter to address. There's a never-ending list of housekeeping matters. In a traditional in-person trial, I would tell the lawyers, make sure that our trial clerk has a phone number to reach you in the event that there's a question or a verdict, because sometimes the lawyers end up leaving the courtroom. They go down the hall, they may go back to their office, they check their messages, they leave the courtroom. So I guess I'm going to ask the same question here. Does Mr. Rogerson, Ms. Irizarry, and Mr. Smith have a number to reach you at in case that you walk away from the remote courtroom to tend to something else and we need to get a hold of you?
I know Mr. Smith does. I don't believe Mr. Rogerson or Ms. Irizarry do.
Well, I'm going to hold to tradition here. And so I'm going to ask any of you that are observing right now, including the media, not to broadcast this phone number, although I guess it will,
Please.
technically it will be on, actually, you know what, it would be on Courtroom View Network. So on second thought, can you message Mr. Rogerson and Miss Arizari? They should be on the chat message.
Chat.
Yeah, chat. Mr.
Okay.
Smith, your number.
You'll be able to send a private chat message to the individuals, Matt.
Matt, do you want me to do that for you?
If you would,
Yeah,
James,
Mr. Cruz, you can send a message to Mr. Rogerson and Miss Arizari with the contact phone number for Mr. Kaczurgas, his cell phone number. I'm going to hold to the tradition of an in-person trial. So,
I'm on it. Yes, sir.
all right. So with that, I interrupt you, Mr. Kaczurgas. What else were you going to say?
that's it.
Okay. All right. So Mr. Muse and Mr. Estelila, you all are back. Have the jurors received the Dropbox and are able to access it?
Yes, sir. We verified that they can all access the files.
All right, then at this time, the jurors are now deliberating. So the question now is, I guess my thought is I'm going to leave my screen up. I'm going to turn my video off. I'm going to mute myself, and you all can do the same. Obviously, I can hear what's going on here. So if the help button is hit or there's a question or an issue that's come up, I'm still here in the physical courtroom 601. I'm also still present in the remote courtroom 601. So for now, I guess we'll be in recess. There's no need to put the recess screen up at this point because we're not really in recess, so to speak, where we're shut down, but we're just in recess waiting for a verdict. And so with that, we'll be in recess as we wait for the verdict. The jurors are now deliberating.
And Matt, I sent those out, so they should have it.
Thank you, James.
All right, well, I'm still present. I'm going to turn off my video and mute myself. Those of you that are observing, we'll be back with you as soon as we have a question or a verdict. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, are you still on with us?
I am.
Your Honor, I'd like to let you know that we do have the verdict form filled out, and I'm calling Mr. Is Mr. Kaczurgas still with us?
So the foreperson has tendered the verdict form to our remote bailiff.
Yes, Your Honor.
Okay. So our remote bailiff will need to then forward the verdict form to the court while we get Mr. Kaczurgas and everyone back in the courtroom. We won't bring the jury back in until everyone's here.
So Your Honor will be receiving that momentarily.
All right.
Mike, I've already called him. Mike, I've already called him.
I don't see it yet, Mr. Smith. We're not on the record yet till we get everyone here and the verdict forms forwarded to the court. Mr. Smith, have you sent it? Oh, Patrick's going to send it. Okay, Mr. Estelila will be sending it.
Your Honor, you'll have it momentarily.
Your Honor,
Yes, sir.
I do have the two forms. How do you want me to send it?
It needs to be sent to me by private message to me.
Okay.
only. I have to review it for legal sufficiency before it's published.
Yes, sir.
I want to do that before we bring the jury in, because if there's a problem, then we'll need to send it back.
Yes, sir. All right, I'm sending you the inquiry form first saying that they have reached the verdict.
All right.
And then the next one is the actual verdict form.
Mr. Estelila, you can now let all six of our jurors into the remote courtroom. For the record, we did have a verdict at approximately 5:35 p.m. It's been sent to the court by private message from Mr. Estelila, our remote bailiff. The jury inquiry form that indicated to the court that a verdict had been reached is going to be marked as court's Exhibit N for identification only. The court has printed the verdict form to be filed in the court file, but obviously in a remote setting, I can't tender the verdict to our remote deputy trial clerk, Mr. Rogerson. So I have forwarded that verdict form to Mr. Rogerson. Mr. Rogerson, without disclosing or publishing it, did you receive it from the court? You're muted, Mr. Rogerson. Did you receive it from the court?
Did receive it. I'm in the process of downloading it now.
Okay, very good. And just make sure before we go any further that it is the correct verdict. It should, at the top, it should have the style of this case with a verdict and filled out and signed by the foreperson. I just want to make sure I sent you the correct form.
It looks like it is like I said, in the process of downloading.
Okay, very good. Right. So any other housekeeping matters before we bring the jury in, Mr. Kaczurgas?
No, Your Honor.
All right, we'll go ahead and bring our six trial jurors, our final six trial jurors into the remote courtroom for the publishing of the verdict, Mr. Muse.
Yes, sir.
Mr. Muse, are all six of our jurors present and accounted for?
Yes, Your Honor. All jurors have entered the remote courtroom.
All right, I'll start with the same question I've been asking all during the trial. Ladies and gentlemen of our remote jury, can you all hear me this afternoon?
Yes, sir.
And can you all see me this afternoon?
Yes.
Yes.
All right, now you can go ahead and mute your microphones with the exception of juror number 3, Mr. Wells. Mr. Wells, you can leave your microphone unmuted. Mr. Wells, you are a foreperson, is that correct?
Yes, sir.
And Mr. Wells, has the remote trial jury reached a verdict in this case?
Yes, sir.
And thank you, Mr. Wells. That verdict form has been tendered to the court. I have reviewed it. I find that there's no errors or omissions in the filling out of the verdict form. I have already tendered the verdict to our remote deputy trial clerk, Mr. Rogerson, via the private chat message in Zoom. And so, Mr. Rogerson, at this time, have you been able to download the verdict form?
Yes, Your Honor.
All right, you may now publish the verdict.
In the Circuit Court, 4th Judicial Circuit in and for Duval County, Florida, case number 2019 CA 1555, Cayla Griffin plaintiff versus Albanese Enterprises Incorporated, doing business as Paradise defendant. Verdict: we, the jury, return the following verdict. 1. Was the total amount of medical damages, including all medical bills sustained by the plaintiff, Cayla Griffin, caused by the incident in question? A, in the past, $44,833. B, in the future, $10,000. What is the total of 2? What is the total amount of any damages suffered by the plaintiff, Cayla Griffin, for any pain and suffering, physical injuries, mental anguish, and emotional distress caused by the incident in question? A, in the past, $100,000. B, in the future, $200,000. Please, so say we all, this 10th day of August, 2020. Four-person signature, Charles Wells.
All right, thank you, Mr. Rogerson. Mr. Kachergis, would you like to have the remote jury polled in this case?
No, Your Honor.
All right, thank you so much. Ladies and gentlemen, the remote jury, I still have a few instructions to give you before you leave today, so please listen very closely. Ladies and gentlemen, on behalf of the parties, the lawyer, and the people of the state of Florida, I wish to thank you for your time and consideration of this case remotely. I also wish to advise you of some very special privileges enjoyed by jurors, whether they be in-person jurors or remote jurors. No juror can be required to talk about the discussions that occurred in the remote jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyer and his representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyer or anyone else about the trial if you wish. You also have the right to refuse to speak with anyone about your experience during this trial. A request may come from those who are simply curious or from those who might seek to find fault with you. It could be from the media, it could be from neighbors or anyone else. It will be up to you to decide whether to preserve your privacy as a juror. You have participated in a very historic event, the first totally remote civil jury trial in Florida. This remote civil jury trial is part of a study that was created by the Florida Supreme Court. For that reason, you will be sent a survey about this process, and that's the only exception to the instructions I've just given you. This survey is extremely, extremely important. You are the only 6 jurors to ever deliberate a totally remote civil jury trial in the United States. The information you provide to the Florida Supreme Court through this survey is extremely, extremely important in order for us to plan the future and the use of Zoom in future trials going forward. So it's very important that each of you fill out that survey because it will provide very important and vital information to the court. So you will receive an email from us, probably from Mr. Smith or Mr. Muse. That email will thank you obviously for your time and attention, but it will also contain a link to that survey that will go directly to the Florida Supreme Court. And so that survey will only ask you questions about the process. There'll be no questions asked of you about the facts or issues that you deliberate in this case. They will deal with the process, how the technology worked, how the things came together to allow you to do your work as a jury, not about your deliberations or the facts or issues in this case. I also want to go back to something that I started with last week during jury selection. I'm only making these remarks because of the historic nature of this case and your participation in this case. I told you before about the fact that this courthouse has been really silent, with the exception of doing phone and Zoom hearings, non-jury trials. We've done our best to keep things moving forward here at the Duval County Courthouse within the limits of technology. This is the very first jury trial we've had here since the middle of March. And it's quite clear that since the middle of March, many things have been suspended, canceled, or postponed due to COVID-19. We can all tell stories about things that have been changed in our life because of the pandemic. But the Constitution was never intended to be suspended for COVID-19. The rights and freedoms that we all share were never intended to be suspended for COVID-19. But with those rights and freedoms that we enjoy come duties and responsibilities. Each of you have joined me in this great American experiment of self-government. And I told you about the phrase, we the people. And we the people are sovereign. We the people are the Constitution. Those freedoms and rights that we enjoy each and every day come at a cost. And you all have paid that cost as it concerns providing for a more perfect union, establishing justice, ensuring domestic tranquility, providing for the common defense, promoting the general welfare, securing the blessings of liberty to ourselves and to our posterity. What was said in 1787 still rings true today in 2020. Because you participated, because you stepped up, because you served and sacrificed by your participation in this civil jury trial project last week and today, the words of our Constitution ring true. The Constitution came to life by your participation in this remote civil jury trial. And for that, the court will be forever grateful. Your community will be forever grateful because the sounds of freedom have been heard once again in this remote courtroom at the Duval County Courthouse. On behalf of all the participants, counsel, the court, all the volunteers who worked so hard since June to put together this remote civil jury trial project, we thank you on behalf, I thank you on behalf of everyone for your work last week and today. I hope this was a pleasant experience for you. We look forward to hearing from you as to your survey answers and responses. But thank you so much. I will never forget you. Will never forget this experience that we've had. Thank you so much. Please answer those surveys that you receive in your email. I can't tell you enough about how important that information is for us. But thank you for your work. I'll never forget you. And we do appreciate it. I wish you a good rest of the day and a good week ahead. And I wish you all the best in whatever you do going forward. And please stay healthy and stay safe. Thank you. Good night and good evening. And with that, this court will now be in recess until 9 a.m. tomorrow morning when we'll return to remote hearings via Zoom and phone. And with that, we are in recess until 9 o'clock in the remote division CVE, Duval County Courthouse. Good night, everyone. You may now leave the remote courtroom.
Good night. Thank you.
Good night.
Thank you.
Thank you.
Thank you.
Thank you.
Anything else to address before we go in recess for the evening?
Not that I can think of, Your Honor.
All right. Again, thank you to everyone for all your efforts, and thank you so much for your patience as we went through the various technology issues. We've learned a great deal the past few days, And unless there's anything else to address, we'll now be in recess in remote division CVE until tomorrow at 9 a.m. Thank you.
Your Honor, if I may, before we leave, I really want to thank the court's IT staff and the clerks and Ms. Hodak and yourself for making what would otherwise be a very daunting task for a non-techie person as smooth as possible. I know it didn't go without hiccups, but without those folks, I don't know what I would have done, particularly Mr. Smith, Mr. Muse. Thanks, guys, and really appreciate it.
Well, Mr. Katurgis, you're quite welcome, but you handled things very well, and you made things go smoothly, and you worked right through it and didn't lose your cool, didn't lose your calm, and you worked right through it. And I can tell you from having been a trial lawyer many years before I became a judge and having presided over a number of trials in nearly 4 years as a judge, that there are no trials, in person or remote, that go without some hiccup or some technology issue or some glitch, whether someone lost their hard paper notes, maybe on a pad of paper, or someone loses their slides, or someone has a problem with their computer. Any of us who've tried cases or preside over cases can tell you stories about things that have happened in other trials. So you've made your way through this admirably, and you're a credit to your colleagues in the Fourth Judicial Circuit who are lawyers that practice here. So with that, thank you everyone for all of your efforts. And I think we're going to close here, and we'll be in recess until 9 a.m. tomorrow morning. Thank you.
Your Honor, you're going to need a clerk tomorrow morning.
Sir?
Are you going to need a clerk tomorrow morning at 9 o'clock?
Recess, I mean in my regular remote civil division CVE, where I'll be doing hearings without the help of the clerk. So I'll
Thank
be
you, Your Honor.
hearing room and regular matters I have to hear each day. But thank you so much, Mr. Rogerson.
Thank you, Your Honor.
Thank you. We're now in recess until 9 a.m. tomorrow morning in the regular civil division CVE. Thank you.
Thank you.
Thank you.
It's been a privilege, Your Honor.